Before you, my Lord, counsel for the applicant. Before you, my Lord, is Counsel Blessed Atwine Mugisha. And the second is Counsel Nicholas Najuna. And before you, my Lord, is the side for the government of the Republic of Burundi. My co-counsel from the chambers of the Attorney General, Elvis Ahurira. And I beg court proceed.
Proceed.
May it please this Honorable Court. My name is Blessed Atwine Mugisha, and I represent the applicant in this matter, Health and Refugees Initiative, together with my co-counsel, Nicholas Najuna. We shall use 30 minutes of this Honorable Court's time. I will use 14 minutes to address this Honorable Court on the brief facts, the statement on jurisdiction, issue 1 and issue 2. My co-counsel will use 13 minutes to address this Honorable Court on issue 3 and issue 4. We reserve 3 minutes for rebuttal. If I may proceed to address this Honorable Court on the brief facts.
Counsel, proceed.
The brief facts of this matter are that the Republic of Burundi was hit by COVID-19 in January of 2020. The 6 million population has been gravely affected. 1 million people have unfortunately died. 3 million people are infected with the virus, leaving only 2 million people that are not affected by the virus at the moment. In a bid to reduce the spread of COVID-19, the government of Burundi has enacted a mandatory vaccination law requiring all adult citizens of Burundi to vaccinate. It has also restricted entry of refugees into the borders of Burundi. That is, those refugees that are not vaccinated, or those refugees who cannot afford on their own account to test to see whether they are positive or negative. The government of Burundi has also implemented the SGR project, that is the Standard Gauge Railway. And this railway line is going to pass through the territory occupied by the indigenous Bachwezi people. These people are disgruntled because the government has not made any plans to compensate them for passage of the railway line through their territory. It is on these facts that we come before this Honorable Court. The jurisdiction of this Honorable Court is not an issue in this matter. The High Court is vested with jurisdiction to hear and determine this matter. The issues that are before this Honorable Court are relatedly or importantly the right to health and the right to property. And these issues have already been determined or interpreted by the Constitutional Court. And therefore, we seek enforcement of these human rights under Article 50 of the Constitution of the Republic of Burundi and Section 3 of the Human Rights Enforcement Act of 2019. I beg to proceed to submit on issue 1.
Please proceed.
Much obliged, my Lord. Issue 1 states whether the mandatory vaccination of its citizens is a violation of Burundi's obligation enshrined in national legislation, regional and international human rights law. We submit on behalf of the applicants that mandatory vaccination law is a violation of Burundi's obligations enshrined in national legislation, regional and international human rights law. The facts under paragraph 8 show that Parliament has enacted a law that requires all adult citizens of Buranda to be vaccinated. And failure to submit to vaccination will attract a penalty of a fine of $360 or imprisonment of for 6 months or both. It is our submission that mandatory vaccination law violates provisions, human rights provisions guaranteed under the Constitution of Buranda, guaranteed under the African Charter on Human and People's Rights at the regional level, and also guaranteed under the International Covenant on Civil and Political Rights at the international level.
Which provisions are those, Council?
Nationally, Article 24 of the Constitution of Buranda provides for the respect of dignity of persons, and it states that no person shall be treated to cruel, inhuman, or degrading treatment or punishment. Article 29(1)(b) of the Constitution of Buranda also provides for the respect of freedom of thought, conscience, and belief. It is these rights and freedoms, my Lord, that embrace or that guarantee the freedom of consent, whereas vaccination is going towards vaccination. At the regional level, Article 4 of the Banjul Charter, that is the African Charter on Human and People's Rights, provides that human beings are inviolable and entitled to respect for dignity and integrity of their persons. Article 5 and Article 8 of the Banjul Charter respectively provide for the respect of dignity of people and the freedom of thought, of conscience. At the international level, the International Covenant on Civil and Political Rights under Article 19(1) provides for the right to hold opinions without interference. My Lord, we submit that subjecting every adult citizen of Buranda to mandatory vaccination is a violation of their dignity, is the violation of their right to bodily autonomy. This,
in light of the Constitution of Buranda, are these rights absolute rights?
my Lord, we submit that under Article 44(a) of the Constitution of Buranda, the freedom from torture, cruel, degrading, or inhuman treatment, which is stated under Article 24 as the respect for dignity of persons, is a non-derogable right, my Lord.
Proceed.
We submit, my Lord, that these rights speak to the right to bodily autonomy, which means that people should have freedom to make their own choices for their own bodies. That means that the state of Buranda cannot force people to vaccinate. They cannot determine what I will take into my body or what I will do to my body for me. Compelling adult citizens of Buranda whatsoever to submit to mandatory vaccination is a violation of their dignity, which is not derogable under Article 44 of the Constitution of the Republic of Buranda. My Lord, the International Covenant on Civil and the International Covenant on Economic, Social, and Cultural Rights, in its general comment number 14 on the right to the highest attainable standard of health, has highlighted under paragraph 30 that the right to health shall not be interpreted as the right to be healthy, that it contains freedoms and entitlements. These freedoms include the freedom from interference and holding opinions with regards to medical intervention or medical treatment. We therefore submit, my Lord, that mandatory vaccination law of all adult citizens of Buranda does violate a non-derogable right, which is the respect of dignity of all persons. And this right is enshrined in national, regional, and international human rights instruments. These regional and international human rights instruments are covenants that the state of Buranda is party to under paragraph 3 of the facts. In conclusion, my Lord, we submit that the mandatory vaccination law is a violation of Buranda's obligations to respect the right to dignity guaranteed under national legislation, regional and international human rights law. I beg to submit on issue number 2, my Lord.
Council, proceed.
Much obliged. Issue number 2 states whether the failure by Buranda to procure vaccines for its citizens was a violation of its obligations enshrined in national legislation, regional and international human rights instruments. It is the submission of the applicant that the government of Buranda has an obligation to procure vaccines for its citizens. This obligation is derived from its obligation to protect or respect and fulfill the right to the highest attainable standard of health, physically, of both physical and mental health. My Lord, in the case of Sehad and others versus Attorney General, the Supreme Court has held that this right to health is guaranteed under the Constitution by reading of Objective 14B and Objective 20 read together with Article 8A and 45 of the Constitution.
Counsel, are you sure it's the Supreme Court?
Much obliged, my Lord. Yes, I am sure. The Constitutional Appeal number 1 of 2013. The Supreme Court held that the right to health is not expressly provided for under Chapter 4 of the Constitution of Buranda. However, it is implied under Article 45 and Objective 14B and 20 of the National Objectives and Directive Principles of State Policy, read together with Article 8A, which makes them justiciable.
When the Supreme Court referred that case back to the Constitutional Court for determination, what was the position of the Constitutional Court in regards to the right to health?
The Constitutional Court, my Lord, held that the right to health is guaranteed under the Constitution of Buranda.
Proceed, Counsel.
Much obliged, my Lord. These objectives, Objective 14B and Objective 20, mandate the state of Buranda to ensure provision of health services to its citizens. Article 8A says that Buranda shall be governed based on the principles of national interest enshrined in the national objectives and directive principles of state policy. At the regional level, the African Charter on Human and People's Rights, under Article 16, states that all state parties to the Charter shall take necessary steps to ensure provision of health services to its citizens. At the international level, the International Covenant on Economic, Social and Cultural Rights, under Article 12, also provides for the right to the highest attainable standard of physical and mental health. And particularly, Article 12(2)(c) of the International Covenant on Economic, Social and Cultural Rights provides that states parties shall take all necessary steps to ensure prevention, treatment of epidemic, endemic, occupational, and other infectious diseases. In this case, my Lord, the pandemic is of COVID-19. In its statement in November of 2020, the Committee on Economic, Social and Cultural Rights stated in its statement on universal and equitable access to vaccines for COVID-19, under paragraph 3, advised that states have to give maximum priority to the provision of vaccines for COVID-19 to all persons. This is in regard to the dire effects that have been brought by the pandemic of COVID-19. My Lord, the facts show, under paragraph 5 and 4, my Lord, that 6 million people of Buranda have been devastatingly affected by the COVID-19. Out of these, 1 million people have already perished because of COVID-19, leaving 5 million people. And yet more than half, that is 3 million people, are already infected with the virus. And only 2 million people are now left unaffected. The spread of COVID-19 is way, way, way very high, as illustrated by the figures, my Lord. And yet the state of Buranda has not done anything to ensure protection of their citizens' right to health. My Lord, we acknowledge that Buranda has taken steps such as stay-at-home orders. It has instituted quarantines and curfews. But my Lord, these are not sufficient because of the effects of COVID-19 on the population, my Lord. This is a health crisis, my Lord. And we submit that vaccines will help to ensure that there is more adequate protection. The measures that have been taken, that is curfew, quarantine, closure of the economy, are only but short-term, my Lord. And vaccines will ensure that there is a long-term curbing of the spread of COVID-19, because vaccines help to give us herd immunity for those that for the general population, my Lord, reducing chances of spread or mortality rate for COVID-19.
Council, how would you reconcile your position on issue 1, where you're asserting that there should be no mandatory vaccination, at the same time you want government to procure vaccines? How would you reconcile your case on those two aspects?
Much obliged, my lord. My lord, the applicant submits that the government of Buranda has a mandate, an obligation to provide or procure vaccines for its citizens. However, my lord, the government of Buranda has no mandate to compel all adult citizens to vaccinate, my lord. The government of Buranda can do other things to ensure that there is efficient vaccination. For example, launching campaigns, education campaigns for vaccination, investing in information and communication, sensitization of the public, such that vaccine hesitancy is reduced, such that people can willingly admit or submit to vaccination. My lord, in conclusion on issue 2, we submit on behalf of the applicant that the government of Buranda, by failing to procure vaccines for its citizens, has violated its obligations enshrined in national law, regional and international human rights instruments.
Thank you, Council.
I would like to invite my co-counsel to submit on issues 3 and 4 and as well make prayers for the applicant.
May I proceed?
Please proceed.
Much obliged, my lord. May it please this honorable court. My name is Najuna Nicholas, appearing on behalf of the applicant. I shall be addressing this honorable court on issues 3 and 4, respectively, and thereon make the applicant's prayers in 13 minutes. Proceeding to submit on third issue. Third issue deals with the restriction of refugees' entry into the state of Buranda. And my lord, while addressing this issue, the applicant will make 2 key arguments. Firstly, that the grounds relied on by the state of Buranda to restrict entry of refugees into its territory contradict the established grounds under the laws that do provide for the refugee rights. And secondly, the applicant will submit that in alternative and without prejudice to the prior submission, Buranda's actions violate the non-refoulement obligation, which is an obligation that prohibits states from returning refugees to countries where their life or physical integrity may be threatened. And my lord, this principle also applies to border points, like in this particular case. Proceeding to submit on my first limb of argument, the applicant submits that the grounds and the criteria for allowing or refusing refugees to enter into Buranda are provided for under Section 5 of the Refugee Act. And these grounds are 2, where an asylum seeker has committed a non-political and serious crime, or where an asylum seeker is enjoying the protection of another country. These rights are also, and these grounds are also provided for on the regional level under Article 12 of the African Charter, to which Buranda is a state party. At the international level, they are provided for under Article 1, C to F of the 1951 Refugee Convention relating to the status of refugees, and Article 1, Clause 4 and 5 of the OAU Convention governing the specific aspects of refugee problems in Africa.
Council, is an asylum seeker the same as a refugee?
My lord, we submit that the right to seek and enjoy asylum is interpreted to include a refugee or a refugee who is seeking asylum, because it is collectively known as the right to seek and enjoy asylum.
Proceed.
Much obliged, my lord. We also submit, my lord, that these grounds, as have been stated, are also or amply discussed by the South African High Court in Ali Abubakar versus Refugee Appeal Board, and we submit before this honorable court that they do not include health grounds. Now, my lords, in this particular case, according to paragraph 9, line 7 of the facts, the state of Buranda instead has relied on the health status of refugees, to deny them entry and, of course, enjoyment of their right to seek and enjoy asylum. We submit, my lord, that the state of Buranda, by relying on that health ground, which is not provided for under the law, was in violation of the refugee rights. In any case, my lord, the applicant submits that the respondent state has an affirmative obligation to provide medical care to asylum seekers and refugees. This is a position that has been echoed on by the United Nations High Commissioner for Refugees in its note titled Key Legal Considerations on Access to Territory for Persons in Need of International Protection in the context of COVID-19. Now, my lord, we submit that for the respondent, by the respondent relying on a health status, yet actually it has an obligation to provide medical care. It has violated the rights of refugees to seek and enjoy asylum. My lord, furthermore, the applicant would like to submit before this honorable court that by the state of Buranda restricting refugees from entering its territory, it in that process compel them to return to the countries where they are likely to face a physical or life threat. And this is in breach of the non-refoulement obligation. The non-refoulement obligation is a principle enshrined under Article 33, Clause 1 of the Refugee Convention, 1951 Refugee Convention, and it is a principle that prohibits states from whatsoever situation returning refugees to countries where they are likely to face a physical or a life threat, as in this particular case. My lord, the principle to non-refoulement, or the right not to be refouled, is one that is connected to other rights, and this has been noted by the African Commission on Human and People's Rights in Institute for Human Rights and Development versus the Republic of Guinea. The Commission noted that the encroachment on the principle of non-refoulement is a direct encroachment on the right to life, on the right to integrity of the refugees that have been returned. It is also the applicant's submission that although the respondent may argue that the refugees who are returned at the border were not yet into Buranda, it is the applicant's submission that non-refoulement principle applies also at border situations. And this has been noted by the United Nations High Commissioner for Refugees in its advisory opinion on extraterritorial application of non-refoulement obligations under the 1951 Refugee Convention, that a non-refoulement principle applies whenever the state exercises effective authority. And this includes at border points or non-admission at border points, like in this particular case. My lord, if the applicant may persuade this honorable court with the French, a case from the French jurisprudence that has exactly similar facts as in this case. In French Council of State Judgment number 440756, there was an asylum seeker, a refugee from the Central African Republic, who was seeking refugee status or protection from the French government. However, the border police of the French people had to return the lady and her son. The French Council of State ruled that in whatsoever situations, even if it were under COVID-19 regulations, like it was in that case, the state could not breach its non-refoulement obligation, which is a customary international, is a concept of use cogents and has a status of customary international law. It is the applicant's submission, my lord, therefore, that the state of Buranda returning refugees, but also relying on the grounds that are not provided for under the laws, was in violation of the right to seek and enjoy asylum of the refugees, but also the right to not to be refouled. And my lord, if this honorable court is of no further indulgence to me on this particular issue, I will proceed to address it on issue 4.
Please proceed.
Much obliged, my lord. Issue 4 deals with a continued implementation. Much obliged. Issue 4 deals with a continued implementation of the standard gauge railway, a project that passes through the lands of the Bachwezi people, and the applicant will submit that it is a violation of the national legislation, regional and international instruments. And while addressing this issue, the applicant will make also 2 key arguments. Firstly, that the state has an obligation to preserve and respect the right to property and culture enshrined under the laws of Buranda. And secondly, that this respondent state cannot rely on the exception under Article 26, since it has not fulfilled the condition of making a prompt payment of fair and adequate compensation. My Lord, the right to land, the right to property, it is the applicant's position in that particular regard that in Buranda, the right to property and property belongs to the people. And this is enshrined under Article 26, that the land is vested in the people and not in the state. Now, the right to culture as well is provided for under Objective 24, read together with Article 8A and Article 32, Clause 2 of the Constitution of Buranda, and altogether confer on the state, the respondent state, an obligation to preserve and observe the cultural practices and values. Now, this obligation is also enshrined under the international and regional treaties. In particular, it is provided for under Article 22 of the African Charter on Human and People's Rights, Article 27 of the International Covenant on Civil and Political Rights, and Article 15 of the International Covenant on Economic, Social, and Cultural
so
Rights.
So government has the grounds to take on this land?
My Lord, in response to your question, the government of Buranda is entitled under Article 26 to, if in the public interest, take the land, but there is a condition set for the respondent state, that before taking the land, and this was a position of the Supreme Court of Uganda in Uganda National Roads Authority versus Irumba Asuman, that before the government deprives of the land, it has to make a prompt payment of a fair and adequate compensation. Now, what we look at in this particular case, under paragraph 13 to 14 of the facts, the state of Buranda has gone ahead to deprive of the land of the indigenous Bachwezi without even consulting or even compensating them. Yet this is a standard that has been set by the Constitution, but also has been pronounced on by the Supreme Court of Uganda, which in submission of the applicant binds this honorable court. We submit, my Lord, that the right to culture and the right to property, as has been noted by the International Covenant on Economic, Social, and Cultural Rights Committee in General Comment number 21 on the right to culture, at paragraph 36, the committee notes that these are rights that are closely interlinked, meaning that when you deprive of the indigenous persons their land, you threaten their continued existence, their cultural integrity, but also their subsistence, because this is a land where they are getting a living. And when the state deprives of them of this land without compensating them, they are subjected to difficult situations. But also, my Lord, would like to submit before this honorable court that as seen under paragraph 14 of the facts, already 20 families of the Bachwezi people have already been displaced. And this has been done before the respondent state has made any compensations. And neither has it even made consultations. My Lord, we submit in reliance to the Saramaka people versus Suriname case, in which the rights to property and culture of indigenous persons were upheld. In this case, the state of Suriname was faulted for not consulting the indigenous persons that were occupying the forests of Suriname. And indeed, my Lord, we submit in conclusion, in the interest of time, that the respondent state has breached the rights of indigenous persons by depriving them their land without compensating them. Now, my Lord, it is on the basis of the applicant's submissions made in issue 1, 2, 3, and 4 that we make the following prayers.
Before you make those prayers,
yes, my Lord.
1 minute. How would you reconcile your case with the general limitation attached to the right to property by the Bachwezi people?
I beg your pardon?
How would you harmonize your case in light of the limitation attached to the right to own property, since it is not an absolute right, in light of the limitation attached to it in Article 43 of the Constitution?
My Lord, Article 43 of the Constitution provides for a general limitation on the rights provided for under Chapter 4 and however, it sets a standard, it sets a guideline. And we also submit that this standard is subject to the standard that is also provided for under Article 26, Clause 2B, since the Constitution is also to be interpreted and read as a whole. Now, Article 26, Clause 2B provides that before the state limits the right of property, it has to make a prompt payment of a fair and adequate compensation. This has also been seen in the Supreme Court in UNRA versus Irumba. And
Counsel, proceed with your prayers.
Much obliged, my Lord. The applicant makes his prayers on the basis of Section 9, subsection 1 of the Human Rights Enforcement Act of 2019, which empowers this honorable court to, when it finds that a fundamental right has been breached, to make orders which it may deem appropriate, and this may also include compensation. Accordingly, the applicant prays that this honorable court declares that the mandatory vaccination is a violation of human rights enshrined under the national legislation, regional and international instruments. Secondly, the applicant prays that this honorable court orders the respondent state to procure or otherwise provide vaccines to its population. And thirdly, the applicant prays that this honorable court declares that the restriction of refugees' entry into Buranda is a violation of their rights enshrined under the national legislation, regional and international instruments. And lastly, my Lord, the applicant prays that this honorable court declares that the continued implementation of the standard gauge railway is a violation of the national legislation, regional and international instruments. And my Lord, the applicant rests his case. My Lord, if you may please this honorable court, I am Sigira Adonia, appearing for the respondent, the Republic of Buranda, appearing for the respondent, the Republic of Buranda, with my co-counsel, Elvis Ahura, from the chambers of the Attorney General.
So what's your title? Are you the Attorney General? Are you the Principal State Attorney? Or I need to know.
My Lord, I am the Attorney General of the Republic of Buranda.
Okay.
And if it may please this honorable court, I will begin with issue 1. My Lord, the applicant brings before this honorable court and the issues believing that the government failed its role on mandatory vaccination as it's disrespected the right to life. But the question before this honorable court is on whether mandatory vaccination indeed disrespected or violated the right to life. We presume the fact that according to the Constitution of the Republic of Buranda, specifically under Article 20, Clause 2, states that any organization has a responsibility to defend, promote, and protect these rights, and the right to life is part of these rights. And we believe that the government of the Republic of Buranda had a mandate to look at its responsibilities as it is enshrined still under Article 119 of the Republic of Buranda, of the Constitution of the Republic of Buranda, that a cabinet minister has a role to play in implementing and putting in place policies for the welfare and well-being of the citizens. And we see, according to the facts, my Lord, given to us and paragraph 3, the minister went ahead to institute a law that protected the people against the disease that had been declared a pandemic by the World Health Organization, and that is the COVID-19, which is a disease that is affecting every other country on the globe, my Lord. And therefore, we believe that the government had to take extra steps to protect, as they believe, to protect its citizens, still as provided for and decided in the case of Jacobson versus Massachusetts, my lord, even in the case of Kassam versus Hazard, the same principle was developed. The same principle was developed that the state, in realization of the basic needs for one to have a good well-being of its citizens, will be in place, leaving aside disrespecting and violating any right, to put in place policies to protect the lives of its citizens, because there is a contract between the government and its citizens. And the same relies in this case, my lord, that the government took extra steps to protect its citizens under this. And we believe that mandatory vaccination was not a violation of the right to life. Putting in regard, or not forgetting, that under the facts that we have, my lord, the government of Rwanda, under paragraph 7 and 8, the government of Rwanda was taking all extra steps to look around for the vaccines for its own people. And it was clearly stated in paragraph 8 that as and when these vaccines are in place, it is when this law is going to be implemented. At a point when these vaccines are in place, people were not expected to violate, because vaccines were expected to expire. As and when they are in place, the citizens were expected to compel, respect, and go for vaccination in protection and prevention of the COVID-19 pandemic, my lord. And we believe, and respondent submits that mandatory vaccination as a means of protection of the lives of people was not a violation of the right to life. My lord, I beg proceed to issue 2.
Mr. Attorney General, is this pandemic the first one Uganda has faced, Buranda has faced?
I beg your pardon, my lord.
Is this the first pandemic that the Buranda country has faced?
My lord, it is the first pandemic. And clearly stated in the case, as I said, in the case of Jacobson versus Massachusetts, when the disease of smallpox had invaded the country, it was clearly stated that, leaving aside the comfort zones for people to find refuge in comfortability of being secure of being free from the vaccines, the government takes all responsible positions, as still in Article 25, Clause 1 of the United Nations Declaration on Human Rights, Article 25 of the African Charter on Human and People's Rights, and Article 12 of the ICESA, my lord. The government has the responsibility to take all reasonable and respected steps to protect the lives of its citizens.
There are no alternatives reasonably available for government?
True.
To ensure that its citizens are vaccinated?
My lord, to ensure that its citizens
Have you utilized them?
True, my lord, still under this very case where we have the COVID-19 pandemic, we have utilized and respected all other ways possible where it is stated in the facts that the government in the United Nations Declaration on Human Rights, in the African Chapter on Human and People's Rights, and all international legislation, the government shall take educative, social, and all other possible measures to protect its citizens. And part of them maybe the government has provided. We have seen the government supply face masks. And so we believe that the hesitant people or citizens of the government of Buranda, the government needs to take an extra mile of vaccinating its own people, my lord.
Proceed.
I'll beg proceed on issue 2. Proceeding issue 2, my lord. It is basically, I will draw this court to paragraph 7 of the stated facts, and I'll read them verbatim, my lord, if you'll allow me. Buranda is hoping to appeal in the developed partners in the global north to either donate or offer any aid that will be used to purchase the vaccines, while diplomats are making pitches in various capitals across the world. The government of Buranda has enacted a law to provide for mandatory and of adult citizens. It is on this note that we presume that the applicants have not taken cognizant fact of the facts given to this honorable court, my lord, that the government and the Ministry of Health plus the diplomats are working tooth and nail to provide and procure vaccines for its people. And so we believe, one, in the allegation that the government has failed, it is an allegation and not true before this honorable court.
But facts say you have already procured vaccines for your officials. Why leaving out the citizens at this point? because government officials are vaccinated.
My Lord, thank you so much. Clearly the facts have it that essential workers who are frontliners are people that have been prioritized in this fight of COVID-19. And we believe that, one, we respect the fact that these frontliners and essential workers, given examples of doctors, given examples of government officials that work here and there and their offices cannot be closed, need to be prioritized, which the government has done. And therefore still, with a few vaccines that were donated, 500,000 vaccines. And therefore the government has gone ahead to apply to the north, has gone ahead to apply to the global north to seek for aid or donation, has gone ahead for the diplomats to go and pitch to these more civilized countries, my Lord.
Mr. Attorney General, you're
Yes,
telling
please.
this honorable court that the government has no resources to procure vaccines for its citizens. What's your stand on that?
According to the facts, my Lord, still, the country or the Republic of Buranda is a third world country. It has a crawling economy where it is struggling to provide for its citizens. And still it is found in a volatile region where there are a lot of civil wars, where people are at stake. And we find before the COVID pandemic actually came on board, there were insecurity cases. And so we believe, one, the nature of the economy of the country of Buranda, two, the state in which the country earns and the economic standing, we believe that we are taking reasonable steps to provide and procure vaccine for our citizens, my Lord. I beg to proceed.
Proceed.
Still on this allegation of failure to procure vaccines, my Lord, we look at that basic paragraph that has not been given attention by the applicant. Still under Article 12 of the International Convention on Economic, Social and Cultural Rights, the government is mandated to take all necessary steps to provide for its citizens. Under Article 8A, where they said it is a state policy, my Lord, still under Article 16, Clause 2 of the African Charter on Human and People's Rights, the government still needs to take necessary steps because it is its responsibility. And I believe that the government of Buranda is taking all necessary and reasonable steps, fighting hard to provide and procure vaccines for its citizens, my Lord.
Mr. Attorney General, what practical steps have you taken as government?
What practical steps has the government of Buranda taken? One, the government of Buranda has gone ahead as jotted down in the facts, that the government of Buranda has gone ahead to seek for aid, to seek for donations of these vaccines. Two, the government of Buranda has not rested, leaving its diplomats to go and pitch for survival and pitch for guidance and seek for help in countries that are more developed to come for rescue of their own country, of their own citizens in Buranda, my Lord.
Would you harmonize a position where you have, because it is within your mandate to do budgetary policies, at what point do you conclude to award the security department more funds than looking at the health of the citizens?
My Lord, the applicant makes such an allegation.
Because you're seeking to protect people who, at the end of the day, you will find dead. What would be the essence of your security?
My Lord, the applicant makes an allegation that the respondent actually puts more resources on security, which is more important. But this pandemic comes amidst the budget that has already been made. And we believe that in this midst of the budget that has been made to run, it is what they are relying on, that the government puts less attention on health. And this is where we are going, since the budget is already drawn and already taking its lead. It is what we are going ahead, one, to make all reasonable and necessary steps as stipulated in all the treaties I have mentioned, my Lord, and in all the provisions, that the government takes all necessary and reasonable steps to protect its own citizens, my Lord.
Proceed.
And I will proceed, my Lord, on this very last issue, still tackling the issue of or the failure of the government to procure vaccines for its people. It is our government, my lord, for the respondent, that the steps being taken by the government are necessary, are reasonable, as provided and stipulated under Article 16 of the African Charter, on Human and People's Rights, under Article 12 of the ISESA, and under Article 20, Clause 2 of the Constitution of the Republic of Rwanda. And we believe these steps that are being taken by the government of the Republic of Rwanda, as it is clear as it is clear in paragraph 7 of the facts, that the government is going ahead to pitch, the government is going ahead to seek for aid and donation. They are reasonable enough, and we have not failed on the responsibilities and roles in relation to protection of people's rights, my lord. It is our prayer, my lord, that in these two merits, that the government is deemed doing its responsibility. One, that mandatory vaccination, it is done for the good of the people, because it is clearly stated that as and when the vaccines are available, for us to prevent the expiry, people would take on mandatory vaccination. Two, that the steps being taken by the government to procure and have vaccines for its people are reasonable steps, and the government has not failed on the provision of the vaccines for its people. I beg to submit, my lord.
Thank you, Mr. Attorney General.
And yield the floor for my co-counsel for issues 3 and 4.
It may please this honorable court. My lord, my name is Ahulila Elvis, appearing on behalf of the respondent, and I'll strictly handle issues 3 and 4.
Beg your pardon, your name?
My name is Ahulila Elvis. My lord, the applicants aver that the grounds that we took to restrict the refugees are in contravention with the national laws, international laws, and by laws, they cited the cases that are not in our jurisdiction. My lord, we need to tackle on that issue. My lord, looking at the territorial jurisdiction of this court, my lord, in the fact it is stated that these refugees are restricted from entry before they enter our country. It is our submission that this court has no jurisdiction to deal specifically on issue number 3.
So, counsel, what's your prayer?
My lord, it was stated in the case of Olga versus Telos that in instances where the court does not have jurisdiction to handle any matters, it will go into preliminary examinations. And my lord, if this court finds that it has the jurisdiction, still, under Section 3 of the Refugee Act, 2, that the government of Rwanda has sovereignty to either allow or deny the refugees from entering. My lord, the applicant submitted on the principle of non-refoulement.
Counsel, the issue of jurisdiction touches the heart of this court. So you're raising a preliminary objection at this point?
My lord, if this honorable court finds its jurisdiction that confines in this matter,
Because I need to make a ruling on that effect before I proceed. You had scheduling,
yes, my
isn't
lord.
it?
Yes, my lord.
Okay. The applicants. Was this issue brought up during scheduling, the issue of jurisdiction?
My lord, the jurisdiction is as a result of the applicant's submission, basing on the grounds that the government does not take any charge in restricting the refugees that are on the border. My lord, as I submitted under section 3, that the government has sovereignty to restrict or allow refugees. And they have grounds. One is on public security, my lord, and the public interest of the community. My lord, we are in a country, Rwanda, where it is affected with COVID-19. And if we might talk about the interest of the community, in the case of Bahat and another verse, Habib Rajan, I'll read it verbatim, my lord. Public interest was defined to mean the same purpose or objective in which the general interest of community is a concern. My lord, Rwanda is a country that is greatly affected by COVID-19, where 50% of its population has been infected by COVID-19. My lord, restricting the refugees is to prevent the lives of our citizens from further infections.
Violating the international obligations you ratified, the conventions you ratified.
My lord, if I may submit on Article 123, Clause 2, the government of Rwanda, under its constitution, it has the mandate to make laws that govern the treaties and conventions. And the government of Rwanda is a juristic state.
But, Mr. Attorney General, the government went ahead to domesticate the Refugee Act, isn't it? You took an extra step to uphold your international obligations. Are you running away from them at this point?
My lord, under Section 3, as I already stated, the sovereignty of the state under two grounds. It is not our submission that the government should violate the obligation, but it is our submission that the government of Rwanda should protect the interests of its community that is being affected by COVID-19. My lord, the applicant submitted that the government of Rwanda violated the principle of non-refoulement under Article 33(1). My lord, it is our submission that the Refugee Convention 1951, under Article 33(2), it sets two exceptions to the principle of non-refoulement. We have public interest, we have public security, and my lord, the government at this time is protecting the interest of its citizens. My lord, we are looking at these fundamental rights as a whole. Restricting the refugees who are entering into our country and allowing the 6 million people again succumb to COVID-19, my lord, it will be a grave mistake. And the government, for its purpose, it has taken further steps to make several rules. And they have worked.
Council, isn't that practical measure that the government is seeking to take arbitrary? Still in lieu of your international obligations. Isn't it arbitrary and oppressive to the refugees?
My lord, this restriction is not in any form arbitrary. My lord, if I may proceed on the applicant submission on the second averment. My Lord, in the case of Gabriel Gashumba v. Zimbabwe, my Lord, applicants for the refugee status were denied on the grounds of not fulfilling the requirements of the country of Zimbabwe to allow them. My Lord, the Court of African Court on Human Rights and People's Rights clearly found the applicants that they were not fit to be granted the refugee status. My Lord, it is our submission that this court finds the government of Rwanda not in violation of its obligations to respect international law. And it is in fact in respect of its international law. My Lord, under Article 33.2 of the Refugee Convention, it is stated that, read together with the protocol, under Article 10, it is stated that the government will take the necessary restriction to respect its obligation in the protection of its citizens, and these obligations include the restrictions. My Lord, if I proceed on the second issue, on the violation of the right on property. My Lord, the applicant submitted that the government has its exceptions under Article 26.2. And as I clearly stated, that the public interest is for the general community. The Minister for Development, Hosea, has clearly stated that the standard gauge area will be of the benefit of the Bachwezi people. My Lord, we gave compensation of 100 acres to people that were staying originally on 10 acres. My Lord, we submit that that is compensation is actually fit for the applicants, and it is not in any way in the violation of their right to own property. My Lord, under Section 8 of the Land Acquisition Act, basing on the fact that the applicant submitted that we have not in any way compensated the Bachwezi, it states that the government having interest in any land for public interest and for health interest shall compensate anyone with an interest in that land. My Lord, under paragraph 14, if I may refer you to under paragraph 14 of the facts, it is clear that the 100 acres are sufficient compensation to have the interests of the public.
I didn't get your title. Clarification from court. Have you already handed over the 100 acres to the Bachwezi people?
My Lord, at the time when we handed over the 100 acres to the Bachwezi people,
have you handed them over, or you have merely identified that land is somewhere that you will seek to give to the Bachwezi?
My Lord, under our facts, the construction of the standard gauge railway was stalled down due to the violations, to the violent demonstrations of the Bachwezi people. My Lord, 20 homes had already shifted. We had compensated the Bachwezi with 100 acres. It is our submission that they should not raise an issue on compensation, but rather this court finds it right that the government of Rwanda is in fulfilling its obligation to ensure that there is development that benefits the whole entire society.
Because the facts here are saying you have merely identified over 100 acres where you will relocate You need to consult with your boss. Because I need clarification on this. Have you compensated the Bachwezi?
My lords, if we may refer to the fact under paragraph 14, it is stated that Darukira Bachwezi has stated the applicants have not brought any evidence that they have not acquired this land. It is stated by the Darukira Bachwezi. The Attorney General comes and says that we compensated, in the facts, 100 acres to the Bachwezi.
Mr. Attorney General, is that the position? Okay.
If I may proceed, my lord.
Proceed.
In the case of Katamba versus the Uganda National Roads Authority, it was held that land can be acquired by government after compensation reached on by a valuer. My lord, it is our submission still that 100 acres to any valuer, it would be sufficient compensation to the Bachwezi. My lord, if I may proceed on the applicant submission on the government obligation to take its position that violates the rights of the Bachwezi. My lord, this is a right that is irrevocable. My lord, under Article 43, the right to own property is limited, and the government is coming to limit this right for public interest under Article 26(2) and under Article 237. It is our submission that the government has not violated the rights to own property of the Bachwezi, but it has fulfilled its obligations under national legislation, international, and it has fulfilled the respect for human rights. My lord, we therefore pray that this court dismisses this application and that an order to inject the violent Bachwezi from that land. My lord, if I might make my prayers. The applicant submitted that we violated the right for mandatory vaccination.
1 more minute before you make your prayers. It's clear that you do not recognize, as the state, you do not recognize the Bachwezi's right to communal property. How are we sure that you have even put in place the practical measures to safeguard their inherent rights? Because you are asserting the right is limited. You can limit the same in public interest. But the tendency is you even do not acknowledge their right to communal property. So how best are you going to consider the aspirations, their lives, as the Bachwezi people?
My lord, under Article 26, read together with Article 237, the government can acquire land forcefully if it is in the public interest.
Forcefully?
My lord, if
Forcefully?
if it is in public interest, the government, after compensation, can acquire land forcefully. My lord, it is our prayer that the government of Rwanda is found not in violation with national legislation, regional and international human rights instrument, and that this application is dismissed. So we pray.
Okay. Okay. Any rebuttals, rejoinder?
Much obliged, my lord. In rebuttal, the applicant submits that the respondent state has not demonstrated before this honorable court the justification for mandatory vaccination law. The respondent state, my land brother, the Attorney General, would like to submitted that this was for protection of the right to life, which is non-derogable under Article 22, read together with 44 of the Constitution. However, the respondent state failed to respond to our submission that that mandatory vaccination law violates the right to dignity, which is enshrined under Article 24 and is non-derogable under Article 44A. Therefore, there is no justification whatsoever that violates the right to dignity. My lord, the Attorney General also submitted that ministers have the powers to compel citizens to submit to mandatory vaccination under Article 119 of the Constitution, which is a misdirection to this honorable court. Because Article 119 of the Constitution provides for the establishment of the office of the Attorney General and not for the ministerial duty to compel citizens to vaccination. My lord, again under issue 1, the Attorney General relied on the case of Jacobson versus Massachusetts, but the very same case held that limiting of enjoyment of other human rights and freedoms shall not be without prejudice to the enjoyment of other fundamental and human rights. In this case, the right to dignity, which is a non-derogable right under Article 44. It is the submission of the applicant in rebuttal that the acknowledged vaccine hesitancy by the respondent state cannot be resolved by forceful vaccination. It can only be resolved by mass sensitization, education campaigns on importance of vaccination. Under issue 2, the respondent state said that it has taken steps to provide vaccines or healthcare services for the protection of people against COVID-19. However, paragraph 7 of the facts states that the respondent state is only hoping to appeal. My lord, this is a reluctant step. The state cannot only hope to appeal to various development partners with the effects of COVID-19. My lord, 1 million people have already lost their lives, and 3 million people are infected. The state is reluctant in taking the steps. My lord, the general comment number 14 under paragraph 44 enshrines on this state a priority obligation to provide vaccines under the treatment of pandemics, my lord. And therefore, the Article 21 of the International Covenant on Economic, Social and Cultural Rights that my land Attorney General relied on, that the state must take necessary steps, my lord, is a misdirection of this court. Because under Article paragraph 30 of the general comment number 14 on the right to health, it stated that these steps must be deliberate, concrete, and targeted. Deliberate, that is, they must be intentional, and we have seen that the government is only appealing. And the COVID-19 vaccines that we received from COVAX was not an initiative of government, but merely government was on the receiving end, because this was an initiative of COVAX. My lord, the steps that have been taken are not sufficient, deliberate, concrete, and neither targeted. Under issue 3, the respondent state submitted that the state has sovereignty to deny non-nationals into its borders. We rather submit, my lord, that sovereignty of the state is not absolute when it comes to international customary law. It has been held that the principle of non-refoulement is a concept of jus cogens, and therefore every state, whether you have it as a provision in your national legislation or not, is bound by the principle of non-refoulement under Article 33, read together with 31 of the 1951 Refugee Convention. My lord, under issue 4, it is our submission that whereas the government has provided 100 acres of land elsewhere to the Bachwezi people, the applicant submits that in the case of Uganda National Roads Authority versus Irumba, the Supreme Court held that it is not a matter of forceful eviction or deprivation of property, because there is an obligation by the state to ensure that there is negotiations and compensation that is effective and adequate to the people. The applicant therefore submits that the respondent state has an obligation to enter into negotiations and for adequate compensation. It is not enough to merely rule over the people and state that there is 100 acres here without entering into negotiations with them, as has been held by the case of UNRWA versus Irumba.
Have they allocated these 100 acres?
My lord, they have not allocated the 100 acres, but they have only stated that there is land elsewhere that amounts to 100 acres. However, paragraph 13 states that there has been failure by the government to for consultations and also obtaining consent. It has also been submitted by my co-counsel that the respondent state has an obligation to ensure that the informed consent of the Bachwezi people is put into consideration before forceful eviction. The applicant submits. It is our prayer, my lord, that this honorable court accepts this application and awards the prayers to the applicant. Thank you, my lord.
Okay, this court has had arguments from both parties. We have your submissions on record, your pleadings on record. We shall rely on the authorities from this jurisdiction and beyond you have cited to this court, and we shall give our ruling on notice.
time you guys can be organizing this program.
Some housekeeping rules. Each team, you're limited to 30 minutes. So when you introduce yourselves, let me know what team you belong to, and then apportion the time. Let me know, since you're 2 per team, who will take this number of minutes. Yeah, that's it. You may proceed.
Much obliged, my lord. May it please this honorable court. For purposes of record, my name is Thomas Taremwa, the lead counsel for the applicant, the Health Refugee Initiative. My lord, my co-counsel is Namitala Bridget. We have been accorded 30 minutes of this honorable court's time, of which I will use 13 to resolve merits A and B, and my co-counsel will use 13 minutes.
What's your other name?
Taremwa Thomas. Much obliged, my lord. My co-counsel will use 13 minutes to resolve merits C and D, and we are sparing 4 minutes for rebuttal. My lord, I'd like to proceed to address this honorable court on the preliminary issues of jurisdiction and locus
team?
standi. Much obliged, my lord.
What team?
Team I. Much obliged. I'll proceed to address this honorable court on the preliminary issues of jurisdiction and locus standi. In terms of jurisdiction, my lord, I submit that indeed this honorable court has jurisdiction to hear this matter. Pursuant to Article 50 of the 1995 Constitution of Buranda, any person whose rights have been violated or threatened can apply to a competent court for redress. My lord, pursuant to Section 4 of the Human Rights Enforcement Act, power is vested into the High Court to hear matters relating to violations of rights that are protected under Article 45 of the 1995 Constitution, which provides for rights that are not expressly provided for in the Constitution, under which the right to health falls. My lord, I need to submit that this court has the power and the jurisdiction to hear this matter. I will address this honorable court on locus standi, and pursuant to the provisions of Article 50, Clause 2 of the 1995 Constitution of Buranda, any person or organization can bring an action against the violation of another person's rights or a group's rights. And my lord, the applicant, as an organization in the state of Rwanda, indeed has locus standi before this honorable court. My lord, I'll proceed to address this honorable court on merit A, which concerns the mandatory vaccination and its violation of the rights of the citizens of Rwanda enshrined under the national, regional, and international human rights instruments. My lord, I resolve this merit under 2 header amendments. Firstly, I will establish the existence.
Counsel, first wait. I don't know why you're here.
Much obliged, my lord. The matter before this honorable court presents a matter of enforcement of human rights that have been violated by the state of Buranda, and the applicant is here to seek redress. Much obliged, my lord.
What are the brief facts?
Much obliged, my lord. The facts of the matter before this honorable court are that in January 2020, the state of Rwanda recorded its first case of COVID-19. It has so far recorded 3 million cases of COVID-19, and the state has imposed mandatory vaccination to their people, and it has gone ahead to put penalties that whoever does not vaccinate will be imprisoned or fined, or both. My lord, the state is compulsorily taking over the land of the indigenous community of the Bachwezi in the state of Buranda, and it's also putting restrictions on the entry of the refugees into the state of Buranda. This is the matter that raises the questions that we are here to address before this honorable court. My lord, I'll proceed to resolve merit A under 2 header amendments. Firstly, I will establish the existence of the right to health under the 1995 Constitution and the international law and what it entails. And secondly, I will establish how the government has actually violated the right to health. My lord, on the first amendment, the right to health is provided for under Article 45 of the...
So what's your issue?
Much obliged, my lord. My issue is the mandatory vaccination of the citizens of Buranda indeed violates their rights that are enshrined under the national, regional, and international human rights instruments. My lord, the right to health is protected under Article 45 of the 1995 Constitution, which provides for the rights that are not expressly provided or mentioned in the Constitution. My lord, this position of the law was established by the Constitutional Court in the case of Sayad versus Attorney General, Constitution Petition 16 of 2011, where the court rightly placed the right to health under Article 45 of the Constitution. And on page 81 of the very same case, Justice Madrama notes that Article 45 of the 1995 Constitution is deemed to have incorporated all the treaties that the state has ratified. And pursuant to the facts, on page 1, the state of Rwanda has ratified the International Covenant on Economic, Social, and Cultural Rights, which provides for the right to health under Article 12. My Lord, I'll proceed to establishing how, indeed, the government has violated this right. My Lord, General Comment number 14 on Article 12 of the International Covenant on Economic, Social, and Cultural Rights provides that the right to health must not be understood as the right to be healthy. Provides that the right to health comes with entitlements and freedoms, which include the right to control one's health and the right to control one's body and the right to be free from non-consensual medical treatment. My Lord, pursuant to the facts on page 2, paragraph 8, the state of Rwanda has imposed forceful and mandatory vaccination onto the people, and this excludes the need to have their consent to take the vaccine or not. My Lord, I invite this honorable court to be persuaded by the decision in the case of Refugee adult refusal of medical treatment case of 2002 All England reports on page 449, where the court noted that a patient had a right to reject medication. Therefore, the state of Rwanda should have put into consideration the fact that the people need to consent to the vaccination. My Lord, General Comment number 14 on paragraph 33, it establishes obligations on the state, which in particular, there is an obligation to respect the right to health. And under this obligation, my Lord, the state is supposed to refrain from actions of applying coercive treatment to the citizens. And my Lord, the state of Rwanda has ignored this, and it has gone ahead to establish mandatory vaccination without due consideration of the consent of the people of Rwanda. My Lord, through the development of progressive jurisprudence in Uganda, I would like to invite this honorable court, the attention of this honorable court to the writings of Professor Ben Chiromba in his book, The Fundamentals of Health Law in Uganda, in particular on page 34, where he mentions that much as the state has obligations to make laws that uphold public health, it should do so without unduly infringing and violating other human rights, and in particular, the right to health. My Lord, the mandatory vaccination that is done without due consideration of consent goes against this provision, and it violates the right to health. My Lord, in conclusion of Merit A, I did submit that the state of Rwanda violated the right to health, and I therefore pray that by this honorable court rule and declare that the mandatory vaccination imposed by the state of Rwanda indeed violated the right to health. My Lord, I will proceed to address this honorable court on Merit B, which concerns the failure of government.
Counsel, does the High Court have the power to pronounce itself on a law, on an act of Parliament?
Much obliged, my Lord. My Lord, the High Court has power in particular to determine, in the present case, issues of violations, but when it relates to the violation of a particular article of Parliament or a particular article of the Constitution, then the Constitutional Court would have the mandate to make the interpretation. However, my Lord, to the present facts, the High Court indeed has power to make these declarations because the facts at hand do not reveal any ambiguity that really needs to go to the Constitutional Court and thereafter to the High Court.
Where is the authority to that effect?
Much obliged, my Lord. I beg your pardon.
Where is the authority to that effect, that the High Court can make a pronouncement on an act of Parliament?
Much obliged, my Lord. I beg to restate.
Because I think your prayer is that this court finds that the mandatory vaccination is a violation of the right to health. Because I thought that this mandatory vaccination is arising out of an act of Parliament. So what are you challenging? The act of Parliament? What are you challenging?
Much obliged, my Lord. We are challenging the act, it's the action of mandatory vaccination.
Which is arising out of an act.
Yes, my Lord.
So does the High Court have the power to nullify an act of Parliament?
No, my Lord. The High Court does not. However, my Lord, we are before this honorable court to seek redress in terms of Article 50 of the 1995 Constitution, not in particular to challenge and declare null and void the act that was enacted by the state, but to give redress on the violation of the rights that has
So what redress is that you're seeking for? Because for us to declare, a declaration would just be, how would it help the people?
Much obliged, my lord. The declaration made by the High Court will actually put it out to the public for the guidance of government that the action that is being done without due consideration of the consent of the people is actually a violation of the right to health. And the state may take such guidance to desist from such actions the next time when it's faced with a particular situation.
But then the High Court is usurping the powers of Court of Appeal of the Constitutional Court.
Much obliged, my lord. I beg your pardon.
Then the High Court would be usurping the powers of the Constitutional Court.
Much obliged, my lord. Not necessarily that, my lord. The High Court will only provide redress and it will not declare null and void any act that has been enacted by the state of Buranda. And pursuant to Article 50 of the 1995 Constitution, the High Court can provide, the competent court that we are before at this time can provide redress, even including compensation and passing a ruling. And we are before this honorable court to seek a ruling that indeed this honorable court rules that the mandatory vaccination violated the right to health of the citizens. Much obliged.
We shall come back to that.
Much
Proceed.
obliged, my lord. My lord, I will continue to address this honorable court on merit B, which concerns the failure of the government to procure vaccines, which is a violation of its obligations enshrined under the national, regional, and international human rights instruments. My lord, I will address this honorable court on this issue only in one header comment, under which I will expound on the right to health and the right to life concurrently, because the right to health and the right to life are inextricably bound, and the violation of the right to health automatically leads to the violation of the right to life. My lord, this position was created in the General Comment number 36 on Article 6 of the International Covenant on Civil and Political Rights, where it stated that the right to life includes a constituent right to health, and it was restated in the case of PAO and others versus Attorney General of Kenya, where the High Court of Kenya, speaking through Justice Mumbi Guji, noted that the right to life is put in jeopardy when the right to health is violated. And she further mentioned that the right to life and the right to health are inextricably bound. My lord, the facts on page 2 reveal that the state of Rwanda has failed to procure vaccines for the people of Rwanda, and there are further few 500 vaccines that have been donated to the state are not enough. My lord, we agree and acknowledge that Buranda, as a low-income state, can realize the right to health through progressive realization. However, it's well revealed that the state has not taken the concrete and deliberate measures that it's required to take in order to realize the right to health. My lord, it's well noted in the facts on page 5, paragraph 5, line 4, that the state of Buranda distributed the only 500,000 vaccines that were available to the key government officials, and they were depleted. This was done in exclusion of the general consideration of the
But
public,
Council,
my lord.
whom did you want these vaccines to be given to? Why not the officials?
Much obliged, my lord.
They're
My
the
lord,
one in the public sphere. They're the ones who are doing the movements around, and everyone else is at home.
Much obliged, my lord. My lord, the vaccines should have, in particular, targeted the most vulnerable people in the state of Rwanda. It is not fair that they were distributed to the key government officials who even have a bigger financial muscle to take care of themselves. My lord, there is a population of 6 million in Buranda, and therefore the distribution should have put in fact that there are people that need the vaccines most other than the government officials, and that falls below the test of equitable distribution, my lord, that is established under General Comment number 14 on Article 12 of the International Covenant on Economic and Social Cultural Rights, in particular under accessibility. The requirement of accessibility requires that the medical services that are available should be accessible without discrimination. My lord, the state has ignored this, and it has supplied the only 500,000 vaccines to the key government officials. This really violates the right to health. My lord, I invite this court to be persuaded by the case of Free Legal Assistance Group versus Zaire, where the court pronounced the African Court on Human and People's Rights pronounced itself on the issue of the failure of the state to provide medical services. And it was noted that indeed the failure of the state of Zaire to provide medical services for the people was a violation of their right to health. My lord, pursuant to the facts that the state, much obliged my lord, realized that my time is so far spent, and
You have 2 minutes.
much obliged my lord.
You can
My lord,
conclude what you are saying.
Much obliged, my lord. My Lord, as referring to the case of Free Legal Assistance Group versus Zaire, where the court noted that the failure of the state of Zaire to provide medical services to the people was a violation of the right to health. And it's well mentioned in the facts, my Lord, that there are shortages of vaccines in the state of Rwanda, and the country has clearly failed to provide more vaccines to the people. This is a clear-cut violation of the right to health. And I pray that this honorable court indeed considers this. My Lord, lastly, pursuant to General Comment number 14 on Article 12 of the International Covenant on Economic, Social and Cultural Rights, in particular paragraph 33, it lays out different obligations again upon the state. And the obligation to fulfill requires the state to take budgetary measures that are meant to protect and uphold the right to health. My Lord, it's well revealed in the facts that the government only allocated 3% of its resources to the Department of Health. My Lord, this shows that this was not a targeted step or even a concrete step that was meant to protect the right to health. And this is a clear violation of the provisions of the articles that protect the right to health, my Lord. It's indeed my submission that may this honorable court rule that the failure of the state to procure vaccines for the people of Rwanda was indeed a violation of the rights to health and life. I rest my case.
Okay. Next participant. Bridget, you have 13 minutes.
Whether the restriction of refugees' entry into Rwanda was a violation of their rights enshrined in the national, regional, and international human rights treaties. My Lord, I'll be resolving this issue in two-head averments, wherein I'll establish that indeed the refugees had a right to seek asylum and how the government's actions actually violated the rights to asylum, wherein I'll also provide the possible measures the government could have taken. Proceeding to my first averment, Article 1 of the 1951 Convention relating to the status of refugees defines a refugee as a person who is away from their country, running away from persecution for fear of their life on grounds of political grounds, social or political opinion. My Lord, Article 189 of the Constitution of Rwanda puts an obligation of the government of Rwanda to protect the refugees' rights and to give them asylum into the state. My Lord, pursuant to the facts on paragraph 9, the government of Rwanda sent back the refugees to a state where their life and freedom was at risk, because this is a well-known war zone and these people could easily lose their lives since they were actually running into Rwanda to seek for the protection of their right to life. My Lord, Article 14 of the Universal Declaration of Human Rights provides for that everyone has a right to enjoy and seek asylum in another state. My Lord, these refugees came into Rwanda and they were seeking for their right to seek asylum, but it was denied to them by the government of Rwanda. My Lord, this is also...
Councillor Bridget, you're aware that in our nation we're dealing with a crisis.
Yes, my Lord.
So why would we be putting the rights of the refugees over the rights of the citizens? I think in the facts, we have already lost 1 million people. So our population is down to 5 million. So what is wrong with the government restricting the refugees from coming into the country in a time of a crisis where there is a pandemic?
Much obliged, my Lord. My Lord, Article 31 of the International Human Rights Regulations provides for additional measures that governments could take in times of crisis, which includes quarantine, isolation, or placing the person under public health observations. My Lord, the refugees in question were not given such measures by the government, but they were instead just pushed back to the war zone. My Lord, it is also important to note that human rights experts, including ICC's Leah Zomor, gave principles to govern the rights and freedoms of refugees during COVID-19. And principle number 6 states that the government shall not put health goals that do not respect the right to non-refoulement of refugees. This right is provided for under Article 33, Clause 1 of the 1951 Convention relating to the status of refugees, which provides that no contracting state shall return a refugee to the ground or territories where their life or freedom would be threatened. My Lord, the refugees in question, their right was threatened in the states that they were returned to. My Lord, we are aware of the exception of Article 33, Clause 2 of the 1951 Convention relating to the status of refugees, which provides that a state may take back the refugee on grounds of national security. My Lord, pursuant to the fact that refugees do not pose a matter of national security to the country, even if they pose a risk of health, a risk of a public health emergency, my Lord, the state would have applied jointly or to other international organizations for help. This is provided for under Article 2 of the Organization of the African Union's Charter relating to the status of refugee, which provides that a country shall apply directly and jointly to other member states or to the African Union in case of a burden in regards to refugees. This is also provided for under Article 2 of the UN Declaration of Territorial Asylum, which provides that when a state finds difficulty in granting asylum, it shall with spirit of international solidarity apply for help in the United Nations organization. My Lord, the Buranda country did not apply for such measures. They did not claim that they had.
Country? Isn't that your country as well?
It is my country, my Lord. Much obliged. My Lord, the government of Buranda did not apply to the United Nations, nor to the African Union, or even actually seek help from joint countries in regards to protecting the rights of refugees. My Lord, in the case of MMS versus Belgium and Greece, a refugee was returned back to Greece where he originally arrived. The European Court on Human Rights held that his rights, that Belgium breached its right to the refugee's right to non-refoulement by subjecting him to living conditions that put his life and freedom at threat. My Lord, we therefore affirm that the government had other measures, like quarantining these refugees, applying for help from other countries that it could have taken, rather than sending back the refugees. My Lord, having substantiated on my first issue, I will proceed to Merit D, which is to effect whether the continued implementation of the SGR project violates the rights of indigenous people as enshrined in the national, regional, and international human rights treaties. My Lord, I will resolve this issue by first of all establishing the difference between indigenous and tribal people, wherein I will establish that the indigenous people indeed had a right to land, territories, and resources. Proceeding to my first header verment, the Indigenous Peoples and Tribal Convention of 1989 defines and gives a distinction between indigenous and tribal people, where indigenous people are these people that are native to the land and have been on this land before intrusions like colonization, with a distinct social and cultural nature. My Lord, while tribal groups, these are groups in a sovereign country with only distinct social, cultural, and economic life. My Lord, pursuant to the facts on paragraph 14, the government of Buranda does not recognize communal ownership of land by tribal groups. My Lord, the group in question, the Bachwezi, is not a tribal group because it is native to the land and this provision does not apply to it. Proceeding to my second verment, the indigenous people have a right to land, territories, and resources. This is enshrined under Article 2 of the 1995 Constitution of Buranda, which provides that everyone shall have a right to own land as an individual in association with others. My Lord, the indigenous people in question are owning their land in association, and they have been on this land since the 1800s, pursuant to paragraph 10 of the facts. My Lord, Article 6 of the United Nations Declaration relating to the rights of indigenous people provides for the rights to lands and territories and resources, and no contracting state shall deny these indigenous people such a right. Pursuant to the facts, it's established that the government, pursuant to the paragraph 14, the government established that this right actually doesn't belong to these indigenous people, which violates their right enshrined under Article 26 of the Buranda Constitution and Article 26 sub-article 1 of the United Nations Declaration of the Right Relating to Indigenous People. My Lord, Article 27 of the United Nations Declaration Relating to Indigenous People states and provides for the recognition of the communal tenuous systems of land by the Bachwezi people. My Lord, these people own their land communally and they have a right to do that as enshrined in these statutes, and the government cannot claim that they do not have such a right. My Lord, the government's failure to consult and engage the refugees into the implementation and all the steps that were taken to bring out the SGR project on board was also a violation of their rights enshrined under Article 19 of the Universal Declaration of the Rights Relating to the Rights of Indigenous People, which provides that prior to the implementation of projects affecting Indigenous people, states shall consult and engage these people in good faith in regards to that matter. My Lord, pursuant to the facts on paragraph 13, 13 families of the 20 families of the Bachwezi people have been displaced already due to the floods that have been caused by the implementation of the SGR project. My Lord, we cannot wait to have all our people of the indigenous Bachwezi tribe displaced from their land due to such actions like floods or actually encroachment of the government. The government has claimed that it's going to give compensation to the Bachwezi people as well as giving them 100 acres of land, my Lord. However, we have not seen this work. First of all, the government has not engaged the government has not engaged the indigenous people in the decision-making process and all the key steps that were taken prior to the formation of the SGR project. The government has only made hearsays of the fact that they are planning to give adequate compensation, but this has not happened. The indigenous people have not been resorted, but the effects of the project have already been felt by the people. My Lord, Article 10 of the Universal Declaration relating to the status of indigenous people provides that the state shall give prior and adequate compensation to the indigenous people if there must be relocation. My Lord, we are not seeing this happening, yet the effect of this project is already affecting our people. Article 18 of the Universal Declaration relating to the rights of indigenous people also provides for the right to participate in the decision-making process of the rights that will affect them. My Lord, as earlier submitted, the indigenous people have not been engaged in this decision-making process. Pursuant to the case of Center for Minority Rights Development in Kenya versus Kenya number 276 of 2003, this entailed the Enroy's families that were displaced from their ancestral lands on grounds that the government wanted to put a game park there. My Lord, court held that the government had violated the Enroy's families' rights to lands and territories. And this, I request that this honorable court is persuaded by this court to rely on it that indeed the government of Buranda has violated the rights.
Council Bridget, yes, the facts state that this is paragraph 10, line 1, 2, 3, 4, that this project has stalled due to the violent demonstration conducted by some residents who identify as the Bachwezi. Down even I can't find it, but yes, paragraph 12, that the Bachwezi people have opposed the project since its inception. So how do you expect the government to sit with people who are violently demonstrating? How do you expect there to be any sort of diplomatic arrangement or conversation with a group of people who are violently demonstrating?
Much obliged, my Lord. My Lord, pursuant to the facts, yes, the refugees are demonstrating the implementation of this project, but they are not demonstrating towards the implementation of this project violently. Pursuant to paragraph 13, the leader of the Bachwezi, Bachwezi, said that he has liaised with the government so many times to engage and consult the Bachwezi people in the implementation processes of the SGR project, but they have failed. My Lord, this very government, pursuant to paragraph 14, has claimed that they will forcefully evict the Bachwezi people from this land. And the Bachwezi people have not shown any violent natures in the fact, well, the government has already shown its violent nature by actually starting the project. And the, my lord, I've noticed that my time is fast spent. I request to conclude.
2 minutes.
Much obliged. My lord, the violent nature of the government has already been seen, because the effects are already affecting the people, and 20 families have been displaced already. My lord, as we have substantively submitted a request to proceed to our prayers, and we pray that this honorable court finds that the mandatory vaccination, finds and declares that the mandatory vaccination of the citizens of Buranda is a violation of the rights enshrined in the national, regional, and international human rights instruments. On merit be that the failure of the government of Buranda to procure vaccines was a violation of its obligations enshrined in the national, regional, and international human rights treaties. In regards to merit C, that the restriction of the refugees' entry into Buranda was indeed a violation of its rights enshrined in the national, regional, and international human rights treaties. Well, on merit D, that indeed the continued implementation of the SGR project violates the rights of indigenous people enshrined in the national, regional, and international human rights treaties. I rest my case.
Okay, thank you. Respondents? I trust that you know the rules. Introduce yourself, apportion the time, inform the court about the time you're going to spend, then you can proceed.
Much obliged, my lord. My name is Okelo Isaac Echipu, and I'll be Agent 1 for the respondent state. Together with me is Shiva Namara Grace, who will be Agent 2 for the respondent state. I'll be addressing this court for 15 minutes.
Agent?
Agent 2 for the respondent state, Shiva Namara.
Why are you referring to yourselves as agents?
Beg your guidance, my lord.
Let's call her counsel.
Counsel.
Yeah.
Yeah, counsel for the respondent state. I will be addressing this court on issues 3 and 4. I'll spend 15 minutes of this court's precious time addressing this court on the matters of jurisdiction, our objections to it, and also issues 1 and issues 2. For the rest of the time, then Shiva Namara will make prayers for this court. My lord, if I may proceed on the matters of jurisdiction. The respondent state does not contend that the court does not have a right to enforce under Article 50 of the Constitution. But in as far as interpretation of the provisions of the Act under Issue 1, that is the Act that is making mandatory vaccination in Buranda a requirement, if it calls for interpretation of the violation of provisions of the Constitution, then that's a matter for the Constitutional Court, which is given under Article 137.
I don't think that Counsel Thomas talked about interpretation of the law. His case was that the mandatory vaccination, there's no issue of interpretation, that the mandatory vaccination is a violation of the right to health, not a question of interpretation.
Much obliged, my lord. In as far as I heard counsel submitted that this court should find that the provisions that in fact call for an act of mandatory vaccination should be found in violation of the provisions of the Constitution. But if I had him wrong, then I would find that there's no objection as to jurisdiction as far as enforcement of rights is concerned. But on the second level, we raise an objection as far as issue 4 is concerned. In as far as it challenges...
So, counsel, you're conceding? Are you conceding to that point?
Much obliged, my lord. The respondent state avers that this court has jurisdiction pursuant to Article 50 of the Constitution and under the Human Rights Enforcement Act. And if that is the procedure that the applicants are using, then we have no objection and we concede to the jurisdiction of this court.
Okay, proceed.
On the second level argument, we argue as the respondent state that in as far as challenging the procedure of consultation is concerned, this court does not have jurisdiction. Procedure or any mechanism used by a body in coming out with a decision is challenged through a matter of judicial review, to review the decisions and the process that the body has followed. The applicants here challenge the fact that the state did not consult the Bachwezi, but it's the averment of the respondent said that pursuant to paragraph 13 of the facts, Rukira Bachwezi, before the commencement of the project, went ahead to make requests to the government. These requests amount to a level of consultation. Consultation of a whole Bachwezi clan cannot be done through individual consultations, but through their leaders. It is the averment of the respondent that in as far as the Rukira Bachwezi has taken the views of the people before the government, and the government has moved on without in fact considering their averments, then that should be a challenge under judicial review. And this was court's decision in the case of Belmos P. Ogwang versus the Attorney General, where Belmos P. Ogwang was challenging the workings of the law council in as far as his right to a fair hearing is concerned. Court stated that challenging
Counsel, I'm going to cut you short.
Much obliged.
Yes. Counsel Bridget was not challenging just the consultation process. The applicant is challenging the fact that the holistic action of the government is infringing on the rights of the indigenous groups of people, not just the consultation, it's the whole process. The process has not been complete.
If I'm to be
The process has not been complete to give an outcome. It has not yet been complete. These are plans, because it says that, this is I think paragraph 14, the government of Buranda insists that has been, yes, the government has been threatening to forcibly remove the Bachwezi from the disputed land and no consultation, blah, 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 blah. So the government has been threatening to forcibly remove them, but hasn't yet removed them.
Much obliged, my lord. If I'm to stay faithful to the facts, paragraph 13, line 5 of the facts, 4 of the facts, that prior to the commencement of the construction works, Rukira Bachwezi requested the government to redesign the plans of the SGR project such that the SGR project does not pass through their ancestral and community land, which efforts were in vain. This indeed shows that the commencement has already occurred. Government has gone ahead with the project. And in fact, there was a request made by the Rukira Bachwezi, which means that the challenge here is not a challenge of failure to, in fact, take the request, but failure to implement in making that decision.
Because the construction works have begun, but they're going to go through their land. So there's nothing in the facts to indicate that they have already evicted people. The people who have been displaced as a result of the construction work.
Much obliged, my lord. If I'm
so, Counsel, I will beg that you consider those points and you proceed to your next.
Thank you very much, my lord. It's a averment, therefore, if court finds and deems it fit, therefore, to entertain this application as a whole, I will now submit on my issue 1 and issue 2.
Proceed.
If it may please this court. Merit 1 is as to whether the mandatory vaccination of citizens is a violation of Buranda's obligation enshrined in national law, regional and international human rights instruments. It is a averment of the respondent state that the state has not violated its duties under these particular provisions, but the state has a wide margin of appreciation in as far as the exercise of rights is concerned. And rights in as far as the right to privacy or making decisions is concerned are not absolute rights. These rights are subject to exceptions and limitations.
Who mentioned the right to privacy?
If I was attentive to the submission of counsel for the applicant, they were challenging mandatory vaccination as going against the right to make a free choice by individuals.
You talked about consent and the right to health, but I did not hear the right to privacy. Did you talk about the right to privacy? So address your issues to the issues that the applicants have raised. Otherwise, you'll find yourself wasting a lot of time addressing issues that have not been raised.
Much obliged, my lord. My lord, it's a submission of the respondent state that in as far as the right to consent is concerned, the right to consent is not an absolute right. These rights are subject to exemptions, and these exemptions can be found in Article 2.1 of the ICESA, which states that each state party to the present covenant undertakes to take steps individually and through international assistance and cooperation, especially and technical, to maximize its available resources with achieving progressive or the full realization of rights recognized in the present covenant. It's a submission, therefore, that in circumstances where the state's resources within its ability are not able to fulfill a right in a certain situation, then the state has a wide margin of appreciation. The submission of the respondents state that currently in the state of Buranda, we're having a situation where the neighbors in Buranda are being attacked. They're under violence. So the priority of government at this stake is to ensure that there's security around its borders. That's why we find that the budget, under paragraph 5 of the facts, the budget in the state of Buranda is to the effect that, in fact, there is more that's allocated to the security.
Council. Council Ivan. Isaac.
Yes.
Please address the issues in chronological order. So, are you addressing the issue of mandatory vaccination, or you're addressing the issue of the refugees?
Much obliged, my lord. I'm emphasizing on the wide margin of appreciation that the state has to take. The question is, we have mandatory vaccination as a measure that the
There are
government...
three issues here. One, mandatory vaccination, which is a violation of the right to health. Two, the failure of the government to procure vaccines for its citizens. Three, the right to asylum. And then four, the rights of the indigenous people. So which issues are you addressing?
I'm addressing this court on issue 1, in as regards to mandatory vaccination, and issue 2, which is as to regards the procurement of vaccines.
So you're addressing them wholesomely?
I'm addressing issue 1, my lord. And issue 1 is as to whether the mandatory vaccination in fact violated the rights of the citizens enshrined under
the issue here is that you are introducing the facts of refugees, security, duties of the state. So you're confusing the bench.
Much obliged, my lord. My lord, I'll now proceed to issue 1, and I will take 3 minutes addressing this issue, and I'll move to issue 2. Issue 1 is as to whether the mandatory vaccination of its citizens is a violation of Buranda's obligation enshrined in national legislation, regional and international human rights law. It's a submission of the respondent state that the mandatory vaccination in this particular scenario was necessary and it was demonstrably justifiable in a free and democratic society, as provided for under Article 4.2 of the ICCPR. And as such, rights as to consent are not absolute rights, and as such, they can be put aside in states of emergency. We are seeing a state which is suffering from an attack of an epidemic. We see 6 million people. Out of 6 million people, 1 million people are dead. We have 5 million people. 3 million people are in fact positive. So the question then is, what must the state do in this particular scenario? The state is receiving vaccines, 500,000 vaccines from donations, and it must ensure that these vaccines are in fact utilized. The only procedure and way to do this is to in fact enact a law that makes it mandatory for citizens to take up this particular vaccination. The submission, therefore, the respondent said that it was justifiable under Article 4.1 of the ICCPR. And under Article 2.1 of the ICCPR, it saw the submission of the respondent that the state has a duty to ensure that within its maximum ability, it ensures that in fact it protects its citizens. The submission, therefore, as relying in the case of Akmani, versus Belgium, where there was a spread of smallpox in the country, and the state, in fact, enacted a law that made sure that there was mandatory vaccination. The applicant in that case went to the European Court of Human Rights challenging the actions of the government. The European Court of Human Rights stated that, in fact, the court had a duty to, in fact, limit rights in such scenarios, and the applicant, therefore, had no right, in fact, to consent at that particular period. Your Excellency, sorry, my Lord, if I may proceed now to issue 2, if I have more further indulgence on that issue. Issue 2 is as to whether the failure of Buranda to procure vaccines for its citizens was a violation of its obligation enshrined in national law, regional and international human rights. It's a submission of the respondent state that the state is duty-bound to provide and exercise its duty to provide health care in exercise of its margin of appreciation. The respondent state is progressively realizing its duty to procure vaccines for its citizens. The question then is, what must the state prioritize at such a level? It's a submission of the respondent state that, in fact, the state has to prioritize security in comparison to a priority of health at this particular scenario.
Councillor Isaac, but we are dying. A population of 6 million people, and we have lost 1 million people. We are dying. Why are we? There is no evidence here to suggest that the terrorists have suddenly come.
It's a submission
So
of...
why isn't the government treating the health issue as a matter of national importance as well?
It's a submission of the respondent state that's still staying faithful to the facts. We find that the neighbors to Buranda are in a state of conflict. And they're being attacked.
Crisis right now. We have lost 1 million people. How many people have we lost to war or to terrorism?
Much obliged, my lord. My lord, the submission of the respondent state that if we prioritized giving health, say, majority of the budget, the question then is, if the state is attacked by these evading terrorists and they kill the 6 million people available, what then would the state have taken in fact, giving its margin of appreciation?
Has there been an incident where an entire population has been wiped? An entire nation has been wiped?
This is a
submission of terrorism?
None that I can say of, my lord. But the submission of the respondent state is that in the exercise of its margin of appreciation, the state must, within its resources and within the exigencies of the situation, establish what methods to take. And the submission of the respondent state is that, given the facts, the state has to prioritize seeking for aid, which it has done. It has received a normal donation from the World Health Organization for more vaccines. It has reached out. It has put in place a law to make mandatory vaccination in case there are vaccines available. The state, in fact, has gone ahead to require citizens, in fact, to pay to ensure that there's revenue collected, to ensure that vaccines are bought. The state has taken all the steps within its resources available to ensure that the right to health is promoted. It would be therefore to ask so much of the state at this period to prioritize health and buy vaccines for people who are still at a threat of being attacked by terrorists who are evading their neighbors. The submission of the respondent state therefore that the state has exercised its right of a margin of appreciation to ensure that it makes a balance between prioritizing what must be budgeted for more and what must not be budgeted for more, while also taking necessary steps to ensure that the right to health is not entirely derogated from.
So your submission is that at the meantime, security is more important than health. That's
Yes,
the submission of the respondent.
That's the submission of the respondent, my lord. My lord, the respondent therefore submits that the state has taken its due discretion in exercising its wide margin of appreciation, and as such, it has not violated its duty under Article 12 of the ICESA, and also under Article 8A of the Constitution and Article 45 of the Constitution. I so submit, and I would, if I'm of no more further indulgence, I'll yield the floor to my next speaker. Thank you.
Thank you. You said your name is Okello Isaac. What's the other name?
Okello Isaac Echipu. E-C-H-I-P-U.
Pardon?
E-C-H-I-P-U.
Okay.
If it may please this court, my name is Shiva Grace Namara, and I shall be the co-counsel for the respondent state.
You shall be or you are?
I am. I shall be handling issues 3 and 4. That's Team F. Issue 3, as was raised by the applicants, the petitioners, is to the effect that the restrictions of refugees' entry into Buranda is a violation of its obligation enshrined in national legislation, regional, and international human rights instruments. The petitioners imply that indeed we refused the refugees to enter, and I would like to start by saying that we did not. merely restricted their entry. And because it was a matter of state importance, it was a matter of health, and we were merely ensuring that we protect both the rights of our citizens and theirs as well. Article 21 of the Constitution of Buranda is to the effect that there shall be equal rights for every single individual without any other aspects coming into it. And to say that we restricted them, we refused them when we were merely trying to protect our citizens and them at the same time, is to say that we should prioritize them. Much as we care about their safety, we also care about the safety of our citizens. From the facts, under paragraph B, it's clear that out of 6 million people, 3 million people have contracted this virus, and 1 million of them have lost their lives. This clearly shows that the right to life is clearly at risk for most of these people, and so is their right to health. We need to weigh these rights and ensure that we are able to provide protection for all of them individually and collectively. And in this instance, the right measure to do was to create restrictions. We ensured that those who are already vaccinated may enter, and those that are not may be able to. Those that are not.
But Councillor Shiva, the refugees don't have money. $25 is a lot of money to ask of a refugee. The person is running away from their country. They probably don't have the money. Yes. $25 is a lot of money. If a person is not vaccinated, she must take the test at his or her own cost. How do you balance that? And these are refugees. These are not just immigrants. These are refugees.
Much obliged, my lord. Looking at the facts that were set out by the agreed upon facts, it is clear that the state of Buranda is a country that is even unable to manufacture any of these. So they are either imported, and if they're not imported, as we have seen, they have to seek donations, and we have seen that the donations have been stalled. Without the donations, there is no other avenue other than acquiring these. We are in a state of emergency. The whole world is looking for these vaccine kits, with the vaccines and the test kits. The amount of money, $25 in this instance, is actually very practical.
You're sure about that?
Considering the circumstance, yes.
Proceed.
So, I was saying, it would be restricting upon their right to life, as we have seen under paragraph 26 of the General Comments, number 36. The right to life involves the duty to protect life. And this includes ensuring that you put into place measures for health and ensuring that people are not falling sick. We are clearly seeing that our country has clearly been affected more than others. We have been greatly at risk, and we cannot exactly allow this to continue.
So where are you getting those facts from, that our country has been affected more than others?
The facts state that 6 million people, out of 6 million, half of them have. The World Health Organization has put up comparisons of the different states, and our state clearly has been affected more than others, losing a sixth of their population and a half getting contacted with COVID-19.
So I don't see those statistics here.
Not the World Health Organization statistics. However, the statistics of Buranda are clearly indicated.
Proceed.
Okay. Thank you. So we cannot exactly decide to underlook the other rights that need to also be protected. And so in this instance, the state did the right thing, and I stand by it as its advocate.
Okay.
Then the next issue, the next argument presented by the petitioners concerning the concerning the entrance, was that they had a right to seek asylum. I'd like to direct the court to the advisory opinion of the extraterritorial application of non-refoulement obligations under the 1951 Convention relating to the status of refugees and its 1916 protocol. Under paragraph 6, it states expressly that the convention does not as such entail a right of the individual to be granted asylum in a particular state. Merely, it is providing that the state should, where the states are not prepared to grant asylum to a person, the persons who are seeking international protection on their territory, they must adopt a course that does not result in the removal directly or indirectly. Yes. So in this instance, the state in no way had any right to grant them asylum, and so it cannot be claimed by the petitioners that they did. I would like to move on to the next issue. The second issue that I'm handling, issue 4, concerns whether there was a violation of the right of the Batwezi people through the construction of the SGR project, and the arguments brought out by co-counsel for the petitioners is that these people are first of all indigenous, part of an indigenous group, and that they were not able to fully get their rights because they were not compensated, and so it wasn't exactly binding upon them for them to have gotten, so they did not exactly respect their rights as indigenous people. I disagree. Under the provisions of the UN Charter, UN Convention on the Status of Indigenous People, under specifically Article 10, it states that indigenous people shall not be forcibly removed from their islands, from their lands or territories. No relocation shall take place without the free, prior, and informed consent of the indigenous people concerned, and after agreement on just and fair compensation, where possible, with the option of return. Here it clearly states, it's clear that it's possible for them to be removed from this land. It's not voidable, and in no way can they claim that there is no way that they can be removed. However, it needs to be done properly. I also direct the court to Article 26 of the Constitution of Buranda that states that no, there shall not be compulsory removal from land except for circumstances whereby there shall not be compulsory deprivation of property except for circumstances whereby it's a matter of public health, public use, public order, public security, generally a matter of importance. And in that instance, even after that being fulfilled, there must be prompt payment of fair and adequate compensation prior to the taking of possession. My Lord, prompt payment, I think, would have to be applicable to a situation. In the circumstance that we are in, we have clearly stated that this is a country that, too, is going through very, very volatile conditions. It, too, is a country that has no finances. And for them to expect the payment to be made immediately wouldn't exactly be
And so are you saying
this
that the government is deliberately violating the law?
No.
Because of the situation?
No and yes.
Yes?
No and yes. That we are indeed not, we haven't exactly paid them the compensation of the 100 acres yet. However, in this circumstance, they haven't even agreed to the 100 acres in the first place. They are still complaining about it. So how do you give someone something that they do not want?
But the plans have already been drawn, and the plans state that this project is going to pass through their land.
But at this
and
moment,
it seems like for the Batwezi people, this is more than just money.
Definitely, understandably, it's more than just money. We all have somewhere that we belong to, somewhere that we have all these different, attachments to our homelands and our people. However, in this instance, under Article 28, it's clear that this compensation must be fair and adequate, equitable compensation for the lands, territories, and in this instance, they were given 100 acres. They originally had only 10 acres of land. For us to give them 100 acres is because we are considering the attachment that they have to this land. We are considering the fact that they are having to start again after 1,800 years on this land. We are not merely taking that for granted. However, as I was saying prior, this project has been put on stall because of the demonstration that they have put in place. We cannot exactly finish, we cannot continue our construction without their consent. However, I'd also like to bring into question the fact that they claim that the process wasn't done correctly. However, we had not necessarily the normal way, the usual way, but we had consultation processes with
So
them.
you've been conceding for the last 3 minutes.
Yes, but I'm coming back. So much as they might say that we did not consult them properly, that is not a matter that would be under this procedure, because right now we are determining whether their rights were violated. However, in this instance, we are willing to compensate them. We have had their views. We are not obliged to follow what they tell us to do. It's not a must that just because they've told us to review, much as we've had them, and it's their right to say and for us to hear, it's not their right for us to listen to them and put it into force if it's not the right thing to do. In the case of Poma versus Peru, it was clearly stated that in instances whereby they need to be the economic rights of the state in general and general improvement of the state, they may, in this instance, violate these rights.
Okay. You have a minute?
Okay. Thank you. Lastly, I'd also like to bring into question the fact that I'll go with our prayers.
Proceed.
I pray that this court may agree with the respondent state that indeed we did all that we could in our best efforts. This is a tough time, a time that was unprecedented, a time that we could not have planned for. We have to protect both them and us, because to put them in an instance whereby they too can get sick, because we cannot exactly restrict their right to movement as well. Their right.
Who is them?
Who is
Do you
them?
feel like
the
refugees?
refugees?
Okay.
Yes. We cannot restrict upon their right to movement. We cannot restrict upon so many of their rights, and to let them in without being able to fulfill all their rights would be a disservice to them as well. I also pray that the court shall hold that indeed we are trying our best to ensure that we procure the vaccines. However, in this instance, it's a bit difficult, and we shall do it as soon as we can. Lastly, concerning the Bachwezi people, I pray that the court may permit the continuance of this construction and also approve the 100 acres compensation as it is adequate, and it will generally be a better opportunity for these people who are displaced at the moment to be able to even have more and more land, a vast majority of a bigger space of land to do whatever they want to do with it. Much as they might have this attachment to it, the country must also develop. It's for both our good and theirs. Thank you.
Okay. Counsel for the applicants. You said 4 minutes.
Much obliged, my lord. I will be making the rebuttal in the 4 minutes that we spared, my lord. Starting with the submissions that were made by the first respondent, the first counsel of the respondent. You had earlier guided on the fact that we did not address the right of privacy. We appreciate that. However, counsel went ahead and noted that the respondent relies on the principle of progressive realization in trying to realize the right to health. However, my lord, in the case of Bengal versus West Bengal, the Supreme Court of India noted that the state cannot hide under the blanket of progressive realization and limited resources to fail on its obligations. My lord, the fact that the state of Rwanda is a low-income state does not justify the fact that it should fail to protect the rights of the people in Rwanda. My Lord, the respondent also mentions Article 4, Sub-Article 2 of the International Covenant on Civil and Political Rights, and he relies on the derogation provisions that are provided in there. However, my Lord, reading very well and keenly Article 4, Sub-Article 2 of this provision, it provides that even when the derogations are made, respect should be kept to the provisions of other international laws. My Lord, the state of Rwanda still has an obligation under Article 12 of the International Covenant on Economic, Social and Cultural Rights to uphold and recognize the highest attainable standard of mental and physical health. And it has failed on its obligation. Furthermore, my Lord, he addressed us on Article 2, Sub-Article 1, that still provides for, that puts an obligation on the state to respect human rights, and he used that to justify the fact that the mandatory vaccination was being done to uphold or to do the mandate of the state. However, my Lord, the state is still subject to the provisions of the International Covenant on Economic, Social and Cultural Rights, and in particular, General Comment number 14 on paragraph 33, that raises still the same obligation of respect. And under respect, it notes that the state should refrain from applying coercive and forceful measures of medical treatment to the people. Therefore, my Lord,
this brings me back to the question, why didn't you challenge the act in itself? Why didn't you go to the Constitutional Court to challenge the act? Because it remains a law.
Much obliged, my Lord. The applicant preferred to file a claim under Article 50 of the Constitution, in particular to enforce the violation, because it's a straight cut pursuant to the facts that the actions themselves, even apart from the provisions of the act that was drafted, the actions themselves that are being done and declared by the state, clear cut, they violate the rights that have been mentioned. So the applicant preferred filing an enforcement claim to the High Court. My Lord, the respondent also noted, used national security as a cover to justify the fact that only 3% could be allocated to the Department of Health in the state of Rwanda. However, still, even amidst a pandemic, even amidst wars, the state still has an obligation to protect the people, their health and their life. Pursuant to Article 22 of the 1995 Constitution of Rwanda, the state still has an obligation to protect the lives of the people. Pursuant to Objective 20, still, the state still has an obligation to provide medical services to the people. Still, under Article 8A of the 1995 Constitution, still, the policies that should be drafted by the government should be for the common good of the people. My Lord, the common good cannot be promoted by violating different aspects of the right to health. And we submit that this argument is not admitted. My Lord, the respondent also uses Article 23 of the United Nations Convention relating the status of refugees, 1951, and it decides to rely on the exception that can authorize non-refoulement. However, my Lord, my co-applicant counsel had submitted earlier that the provision of exception lies within public health. In the facts, it's not revealed anywhere that actually the refugees pose a security threat to the state of Rwanda. The only threat that seems to be posed is only to public health, which still goes back to the still running and continuing obligation of the state of Rwanda, still under the provisions of the Constitution that make it subject to international law and also put an obligation on it to respect and protect the refugees when they come to it. My Lord, still this is a clear-cut violation. My Lord, I would love to invite this honorable court to be persuaded by the ruling in the case of Bovia versus Superior Court, 1968, on page 179, the Court of Appeal in California. And I will use this to rebut the much obliged, my Lord.
1 minute. Conclude.
Much obliged, my Lord. My Lord, I will use this case to rebut the assertion that was made by the respondent that the mandatory vaccination was actually meant to protect the people and it was in the interest of the state to protect the people. However, in the case of Bovia versus Superior Court, my lord, the court excluded from consideration the public interest and the interest of the state. It upheld the interest of an individual, Mrs. Bovia, and it held that Mrs. Bovia had a right to have the nasogastric tube removed from her, and she had a right to reject medication, even if it meant causing death. My lord, this case brings up a principle that in matters of complex health decisions, the interests and rights of an individual can be upheld and respected. My lord, I rest my case.
Before you rest your case, you mentioned that counsel for the respondent mentioned that the government was actually taking steps towards making sure that the right to health was not violated, including appealing to development partners in the north and making pitches for the government to get vaccines, and also putting in place this law to ensure that when the vaccines actually come, people actually get vaccinated. So doesn't that counter your argument that the government is not doing enough, that its failure to procure vaccines is a violation to the right to health?
Much obliged, my lord. My lord, much as the government claims to have put steps forward, but it is required under General Comment number 14 on Article 12 of the International Covenant on Economic, Social and Cultural Rights to take concrete, targeted and deliberate steps. And my lord, this whole argument of the government is watered down by the provisions of the facts, page 5, paragraph 5, line 4, where the few available vaccines that were available were distributed to the government officials, excluding the population. If a government is to take a targeted step, these vaccines should have targeted the vulnerable communities of the state. Therefore, these acts that the state claims to have put forward are not deliberate, they are not concrete, my lord, and they are not intended to protect the people of Rwanda, which still makes a violation of their rights. I submit.
Okay, thank you. Councillor Bridget, you have 2 minutes.
Much obliged, my lord. My lord, the respondents have alleged that the right to grant asylum has exceptions under Article 33, Clause 2 of the Universal Declaration relating to the status of refugees. My lord, the applicants are alive to these exceptions, but these exceptions are in line with national security, and the issue at hand is in line of a public health emergency. No. My lord.
The respondents are even saying that there is no direct right to asylum.
My lord, that is not true, because the right to asylum is provided for under Article 2 of the United Nations Declaration on Territorial Asylum, which provides that no contracting state shall fail to grant the full enjoyment of the right to asylum. It's also provided for under Article 14 of the Universal Declaration of Human Rights, which provides that every individual shall have a right to seek and enjoy asylum in another country for their right for freedom from persecution. My lord, the respondents have alleged that this exception applies to these refugees, and we do not agree because it's a matter of national security. My lord, pursuant to the African Organization Convention relating to the status of refugees, it provided that where a contracting state has a burden in reference to the refugees, it will apply to the African Union jointly in a spirit of African solidarity for help from other countries. It's also provided for under Article 2 of the Universal Declaration relating to the status of refugees, which provides that if a country has a burden towards refugees, it shall directly appeal to the United Nations or other countries for help in regards to these refugees. The respondents did not appeal to other countries jointly, or even through the United Nations or the African Union in any matter whatsoever to the fact that they had a burden of the refugees. They just took drastic steps to constructively refer back the refugees to a state where their life and freedom from persecution was at threat. In relation to Merit D, the respondent has alleged that they are protecting the rights of the indigenous people. My lord, pursuant to paragraph 14, it is well established that for them they actually recognize them as tribal people, yet they are indigenous people and they do not recognize their rights. My lord, the The respondents, therefore, do not respect the International Treaty of the Universal Declaration of the Rights Relating to Indigenous People, which they are party to. And I will rest my case on that point.
Okay, thank you. Thank you, participants, and I wish you the best in the next rounds. As you're all very smart. You can sit. You're free to get out.
Attorney General of Rwanda Republic, appearing together with my learned friend Samuel and the applicants. Singoma Samuel. Singoma Samuel. And the applicants are represented by Counsel Blessed Atwine Mugisha, Blessed Atwine Mugisha, and my learned friend Nicholas Najuna. My Lord, I beg that this court proceed. Most obliged.
May it please this honorable court, my name is Blessed Atwine Mugisha, and I appear on behalf of the applicant, Health and Refugees Initiative, together with my co-counsel, Nicholas Najuna. We shall use 30 minutes of this honorable court's time. I will use 14 minutes to submit on issue 1 and issue 2. My co-counsel will use 13 minutes to submit on issue 3 and issue 4, and as well make prayers for the applicant. The brief facts in this case are that the Republic of Buranda was hit by COVID-19 in January 2020. In a bid to stop the spread of the virus, the government of Buranda has enacted a mandatory vaccination law requiring all adult citizens of Buranda to vaccinate. The government of Buranda has further restricted entry of refugees that have not been vaccinated or those that cannot afford to meet they cannot afford tests on their own, entry into the borders of Buranda. The government of Buranda has also implemented the Standard Gauge Railway project, and the railway line is going to pass in the territory of the Bachwezi people, an indigenous community in Buranda. The Bachwezi people are disgruntled with this project because they claim that their rights to property are violated. It is on the basis of these facts that we bring this matter before this honorable court. My lords, the jurisdiction of this honorable court is not in issue, and we appear before this honorable court under Article 50 of the Constitution of Buranda, and as well Section 3 of the Human Rights Enforcement Act 2019, seeking the High Court to enforce the rights that have been violated or infringed by the respondent state.
This Human Rights Enforcement Act is for which country?
The Human Rights Enforcement Act is for the state of Buranda.
Under which paragraph of the facts does it provide that Buranda has a Human Rights Enforcement Act?
My lord, in the instructions for the Moot, it has been stated that the laws of Buranda are similar to the laws of Uganda, and that is why we refer to the 2019 Human Rights.
You mean the rules of the Moot or in the facts?
It was not.
Because the facts only say it has a similar constitution to the Republic of Uganda, and that's it.
My lord, all laws are derived from the Constitution, and Parliament under Article 79 makes all laws for the Republic of Buranda.
So by that same logic, the Republic of Buranda should have its own set of acts of Parliament, and we do not know whether those acts of Parliament include a Human Rights Enforcement Act. So could you please limit yourself to the laws that have been stated as applicable in the facts of the case?
Much obliged, my lord. If I may proceed to submit on issue number 1. Much obliged, my lord. Issue number 1 deals with the mandatory vaccination law and whether it is a violation of Buranda's obligations enshrined in national legislation, regional and international human rights instruments. It is the submission of the applicant that mandatory vaccination law violates the right to dignity and bodily autonomy established in Article 24 of the National Constitution of Buranda, wherein it states that no human person shall be submitted to cruel, inhuman, degrading treatment or punishment. My lord, at the regional level, Article 4 of the African Charter on Human and People's Rights provides, and I quote, that human beings are inviolable and entitled to respect of life and integrity of person. Article 5 of the same charter provides for the respect of the right to dignity. Article 8 of the same charter provides for freedom of conscience. At the international level, the International Covenant on Civil and Political Rights provides under Article 19.1 that human beings must have a right to hold opinions without interference. My lord, the facts under paragraph 8 reveal to us that the health minister has stated to the public that Parliament has enacted a law requiring all adult citizens of Buranda to submit to vaccination. My lords, we submit that this mandatory vaccination law does infringe the right to dignity of people and bodily autonomy, which means that every person has a right to determine or to make choices for their own bodies. And the government of Buranda cannot come and say that you will do this or this will be done to you without seeking consent or without any legal provision that they base on. My lord, we submit that the right to dignity...
I think the legal provision that they are basing on is Article 43 of the Constitution, which makes some of these rights that you're referring to non-absolute.
Much obliged, my lords. My lords, we submit that the right to dignity, the right to respect dignity, is provided for under Article 24. And this right is made non-derogable under Article 44A of the Constitution of Buranda, which means that the respondent state cannot in any way whatsoever violate this right. The right to respect dignity of people and, and prevention from degrading treatment cannot be derogated from, my lords. My lord, it's a submission of the applicant.
My understanding of Article 24, if you read it in line with, just giving words the meaning that the words they keep company with have, it's relating to torture, cruel, inhuman, and degrading treatment. So are you submitting to this court that cutting off or pulling out someone's fingernails is equivalent to a simple injection that's saving someone's life? That they are both in the same measure cruel, inhuman, and torture?
My lords, it is the submission of the applicant that the right to has been interpreted by the Committee on Economic, Social and Cultural Rights in its general comment number 14 on the right to the highest attainable standard of health, under paragraph 2, states that the right to health should not be interpreted as the right to be healthy. It states that the right to health contains freedoms and entitlements, and these freedoms include the freedom to freedom from interference, even when this interference is medical interference. We submit, my lords, that basing on that, the respondent state of Buranda cannot make vaccination mandatory for all adult citizens, violation of their respect, of their right to dignity and integrity of person.
I understand the submission you've just made, but as an alternative argument, but you still didn't answer my question. Vaccination, is it to be looked at as torture in the same way that pulling out a suspect's fingernails is also torture?
My lords, the applicant submits that it should not be looked to that way, that pulling out someone's nail is not in the same way as torturous as subjecting someone to vaccinate against their will. However, my lords, in the alternative, we would like to submit that even when the right to bodily autonomy may be limited, we submit that it does not pass the test under Article 43 of the Constitution of Buranda. Article 43(2) of the Constitution of Buranda states that public interest or any limitation in regards to public interest, in this case public health, shall not go beyond that which is acceptable and demonstrably justifiable in a free and democratic society. It is the submission of the applicant that in the case of Charles Onyango Obo and Andrew Mujuni Mwenda versus the Attorney General, the Supreme Court adopted the three-part proportionality test to determine that which is acceptable and demonstrably justifiable. The three-part proportionality test is that it must, the measure or means must pursue a legitimate aim, in this case, protection of the right to health and life of the citizens of Buranda. 2, it must be necessary in that it must not be arbitrary and or the least restrictive means. We submit, my lords, that this mandatory vaccination law is arbitrary in the sense that it is for all adult citizens of Buranda whatsoever. My lords, there has not been any steps taken by the respondent state to ensure that every citizen is compatible, have their bodies compatible with the vaccines. My lord, we submit that some people may not be compatible with the vaccine, such as people with underlying conditions, pregnant women, and these vaccines may...
What's the basis for this information? Because you're not a medical expert.
My lords, we submit that the state has a duty to make sure that these vaccines are compatible with each and every one, and the state has not done so.
So my question is, what is the basis of your submission that some people's bodies are not compatible with the vaccines? We don't even know what the vaccines are.
Much obliged, my lords. My lords, the World Health Organization, in its publication, measures and treatment for COVID-19, underlines, states that there are vaccines that have been established for treatment of COVID-19. But some of these vaccines have negative effects to those to their recipients, my lords. And some of these...
as the judge has said, how are you basing this opinion? Because the Minister of Health, under paragraph 8, states that the vaccination is a time-tested strategy for responding to infectious diseases. So what are you basing on to say that this vaccination should be termed illegal? This mandatory vaccination?
Much obliged, my lord. My lords, it is not the submission of the applicant that vaccination is a wrong measure. It is the submission of the applicant that compelling citizens to submit to vaccination is a violation of other fundamental human rights and freedoms. My lords, we submit that whereas vaccination is a time-tested measure for the prevention of infectious diseases, it cannot be made mandatory, my lords. We also submit, to continue with the three-part test, the third part is that the measure must be proportionate. My lords, we submit that this mandatory vaccination law is not proportionate in the sense that the measures that have been used are the imposition of criminal sanctions makes it disproportionate, my lords. Under paragraph 8 of the facts, it is stated that anyone who does not commit to this vaccination shall be liable to imprisonment for 6 months or a fine of $360. My lords, if we can borrow jurisprudence from Europe, the European Court on Human Rights stated in the case of Vavrica and others versus the Czech Republic that a case which concerned mandatory vaccination of all children in the Czech Republic, my lords, the European Court on Human Rights held that for mandatory vaccination to pass the proportionality test, sanctions that are put to ensure this mandatory vaccination should not be criminal, but rather should not be punitive, but rather preventive. My lords, we submit that the imposition of criminal sanctions makes this mandatory vaccination law disproportionate.
But the way you've submitted on that case against the Czech Republic, it was for mandatory vaccination of children. So it would be understandable for you not to put in place punitive measures against children violating the law. If I've understood your submission correct. Isn't that context different from the one at hand?
My lords, we submit that the European Court, whereas the problem or the case before it was dealing with mandatory vaccination of all children, the European Court pronounced itself on the three-part proportionality test, and and its holdings was not in regard to whether at the case before it was involving children or not. It was regarding the passing of the test when it comes to mandatory vaccination, my lords. In conclusion, with the submission of the applicant, that mandatory vaccination law is a violation of the right to dignity and bodily autonomy of the citizens of Burundi. If I may proceed to issue number 2. Issue number 2 deals with whether the failure of Burundi to procure vaccines is a violation of its obligations enshrined in national, regional, and international human rights instruments. It is a submission of the applicant that the failure by Burundi to procure vaccines for its citizens is a violation of its obligation to respect the right to health. The right to health has been held in SEHAD and others versus Attorney General, that it is derived from Objective 14B, and 20 of the national objectives and directive principles of state policy, which mandate the state to provide health services to its citizens. My lords, we submit that the right to health has been violated by failure to procure vaccines. My lords, I request for 1 minute to conclude.
Yeah, 2 minutes.
Much obliged, my lord. At the regional level, Article 16 of the African Charter on Human and People's Rights mandates the state to take all necessary steps to ensure that they protect the health of their people. In the same vein, at the international level, Article 12 of the International Covenant on Economic, Social, and Cultural Rights provides for the right to the highest attainable standard of health, and sub-Article 12(2)(c), it states that state parties to the covenant must take all necessary steps to ensure that they protect their citizens from occupational, epidemic, endemic, and other infectious diseases. In this case, the COVID-19 pandemic. Under paragraph 4 of the facts, we see that the 6 million population has already dropped by 1 million people who have succumbed to COVID-19. 3 million people of those that are left are already infected with the virus. And it is a mandate of the respondent state, my lords, to procure or otherwise provide these vaccines to save the population of Buranda. My lords, we also submit that the Committee on Economic, Social and Cultural Rights made a statement after the outbreak of COVID-19 in November 2020, which is a statement on universal and equitable access to vaccines for COVID-19, and it said in paragraph 3 that under general comment number 14 on the right to health, paragraph 44 gives the state priority obligation to ensure provision or procuring of vaccines to its citizens.
Council, this duty of the state you're talking about to its citizens, doesn't it then justify the mandatory law on vaccination?
My lords, it is the submission of the applicant that vaccines are important for the prevention of the spread of COVID-19. However, mandatory vaccination is a violation. My lords, we submit that even in the protection of the right to health, any limitation must be in regard to the legal, to the laws that provide for that limitation. And we provide and we submit on behalf of the applicant that mandatory vaccination law is a violation of the right to dignity and bodily autonomy. However, the state has a duty to provide these vaccines, but not make it mandatory. My lords, it is the submission of the applicant, in conclusion, that this respondent state has a duty to procure vaccines, to take all necessary steps, deliberate, concrete, and targeted, to ensure provision of health services. And it is my submission, vaccines for its citizens is a violation of its obligations enshrined in national, regional, and international human rights instruments. If I have no further indulgence to this court.
What orders do you seek in relation to your issue 2?
My lords, we pray that this honorable court orders the Republic of Buranda to procure or otherwise provide vaccines for its citizens. With leave of court, I beg to invite my co-counsel to submit on issue 3 and 4 and make prayers for the applicant. Much obliged.
May it please this court, with your permission, I will proceed. Much obliged, my lords. May it please this court, I am Nicholas Najuna, appearing on behalf of the applicant, and I will be addressing this honorable court on issues 3 and 4, and thereon make the applicant's prayers in 13 minutes. Proceeding to submit on the third issue. Issue 3 deals with the restriction of refugees from entering the state of Buranda, and the applicant will submit that it is a violation of the national legislation, regional and international instruments. While addressing this issue, the applicant will also make 2 key arguments. Firstly, that the grounds relied on by the state of Buranda to restrict refugees from entering its territory contradict the established grounds under the international and regional laws that provide for refugee rights. And secondly, we will submit that in alternative and without prejudice to our first argument, that the state of Buranda, by failing to accept refugees into its territory, it contradicted the non-refoulement obligation under Article 33 of the 1951 Refugee Convention. Proceeding to submit on my first limb of argument, it is the applicant's humble submission that the refugees in this particular case that have been returned to countries where they are going to face a threat to life or physical integrity have a right to seek and enjoy asylum. This right on the regional level is enshrined under Article 12 of the African Charter on Human and People's Rights, and on the international level, it is recognized under Article 1 and 2 of the OAU Convention governing the specific aspects of refugee problems in Africa. My lords, we submit that the grounds that are laid under these treaties and conventions are that a state
Council, Article 33 prohibits refoulement on basis of race, religion, nationality, membership, or membership to a particular social group or political opinion. So are you trying to say that the respondent refouled these refugees on basis of those things?
We submit that the respondent is refouling the refugees on the basis of their health, which is... Yes, my lord. We submit that the grounds that are supposed to be relied on by a state to restrict refugees' entry into their territories are one, that if a refugee or an asylum seeker has committed a non-political serious crime, and secondly, if the refugee is enjoying the protection of another country. However, my lords, as we look at as paragraph 9, line 7 of the facts of this case, the respondent has basically relied on the health status of refugees because they are COVID-19 positive or because they cannot afford the tests for against COVID-19. This is a ground that is not provided for under the conventions that protect refugee rights, and for the respondent state in relying on those grounds was a violation of their rights. In any case, my lord, the applicant submits before this honorable court that the respondent state has an affirmative obligation to provide medical care to refugees and asylum seekers. This is a position noted by the United Nations High Commissioner for Refugees in key legal considerations on access to territory for persons in need of international protection in the context of COVID-19 at paragraph 5. Now, my lords, it is the applicant's submission that for the respondent state that has, in fact, an obligation to provide medical care, it cannot then rely on that ground to return the refugees or even restrict them from enjoying their right to seek and enjoy asylum.
Does the respondent state have a duty to refugees that it hasn't yet accepted into its country?
Yes.
A duty to provide them with medical care?
Yes, my lord. We submit that it has been submitted by the United Nations High Commissioner for Refugees that the obligations of the state also extend to border entry points where the state exercises effective control, and those refugees are in position to...
But by that same document that you're referring to, border point entry points, meaning the ones that the state has control over, are those border points that are within its territorial control. So someone is at your door, they are knocking to enter, and you tell them, your health is going to endanger the rest of my citizens. Do I have a duty as the state to extend medical care to a person that I haven't yet even ushered into my territory?
Yes, my lord. The respondent state has an obligation to provide medical care to persons who are seeking refugee status in its country, and also these are persons who are at its border entry points. And would like also to submit and rely on the African Commission on Human and People's Rights in Institute for Human Rights and Development in Africa versus the Republic of Guinea. In this case, the African Commission was also interpreting Article 12 of the African Charter, and as well as the 1951 Refugee Convention. And this, the Commission as well considered the principle of non-refoulement. This is a principle that extends even at border entry points. Now, the principle also entails the fact that refugees have to be protected by the welcoming state. In this particular case, the state of Buranda. My lords, the applicant will further submit that the respondent state, by failing to accept refugees into its territory in that particular way, compelled them to return to countries where their physical integrity and life were threatened. This is a violation of the non-refoulement obligation as seen under Article 33, Clause 1 of the 1951 Refugee Convention.
It could be argued that ever since 1951, when this convention was drafted, the world has not encountered a pandemic. And so we have to understand the obligations that arise out of Article 33 within our new COVID context. I do not think that drafters of that article intended to overburden states in times of a pandemic. So wouldn't you take we would be more compelled to take a lenient view on the respondent state in this regard. Do you have anything to say?
Yes, much obliged, my lords. It is the applicant's submission that the United Nations High Commissioner for Refugees has advised in its key legal considerations on access to territory for persons in need of international protection in the context of COVID-19 response at paragraph 5 has advised that whereas states can put in place screening protocols, can put in place testing for refugees entering their territory, this cannot be relied on by the respondent state to refall or even refuse asylum to the asylum seekers and refugee persons. It is thus the applicant's submission, my lords, that the respondent state, by relying on the grounds that are not provided for under the 1951 Refugee Convention and the laws that it is a party to, but also by refouling the refugees to countries where their life would be threatened, was in violation of their obligations under the national legislation, regional and international instruments. My lords, if firm of no further indulgence to you on issue 3, I will proceed to address this honorable court on issue 4. Much obliged, my lord. Issue 4 deals with the continued implementation of the standard gauge railway project, and it is the applicant's submission that it is a violation of the national legislation, regional and international instruments. Now, my lords, the applicant will be submitting that the respondent state has an obligation to protect the rights to culture, which is also connected to the right to land and property of the indigenous persons in Buranda, and also the applicant will submit that the respondent state cannot rely on the exception under Article 26, since it has not made a prompt payment of fair and adequate compensation, which it is its condition to fulfill. My lords, it is, proceeding to submit on my first limb of argument, it is the position of the applicant that the state, the land and property in Buranda is vested in the people rather than in the state. This is provided for under Article 26 as well as Article 237. Now, we also continue to submit and rely on Objective 24, read together with Article 8A and Article 32, Clause 2 of the Constitution of Buranda, that the respondent state has an obligation to preserve but also to observe the cultural values and practices of its people. On the international level, this right is observed and provided for under Article 15 of the International Covenant on Civil and Political, on Economic, Social, and Cultural Rights, beg your pardon. It is also provided for under Article 27 of the International Covenant on Civil and Political Rights, and accordingly, the ICCR Committee, the International Covenant on Economic, Social, and Cultural Rights Committee, in its General Comment number 21, notes that the right to property of indigenous persons is interlinked with their rights to land, their rights to access resources, since it is the fundamental basis of their survival, the fundamental basis of their identity, my lords. We also submit and rely on the case of the Supreme Court case of Uganda National Roads Authority versus Irumba Asuman. In this particular case, my lords, the Supreme Court noted that the Supreme Court of Uganda noted that there is a condition, whereas Article 26 recognizes that the state may deprive land of its people. It has an obligation to ensure that it makes a prompt payment of fair and adequate compensation before depriving of that land. Now, my lords, looking at the facts in paragraph 13 and 14 of this case, the respondent state has gone ahead to deprive of the Bachwezi their land without even consulting them, and neither has it made any consultations regarding the compensation. Yet the Supreme Court has pronounced itself on the matter in regard to Article 26, that before the state deprives the land, it has to make a prompt payment of adequate compensation, and has not been done in this particular case. My lord?
In this case, whom was the state supposed to compensate? Because it seems the land ownership is unclear.
In the case of Uganda National Roads Authority versus Irumba?
No, I mean in these facts. whom was the government supposed to compensate? The Bachwezi as a group, their cultural leader, or all of the 20 families individually?
My lords, much obliged with the applicant submits that the respondent state was supposed to be recognizing and compensating the property rights of the Bachwezi generally, because they also have a collective right. And my lords, we want to submit and rely.
So the way my understanding of Article 26 is that government identifies land that would be affected by a public project. They sit down with whoever is the owner of that land, negotiate, give them prompt, fair, and adequate compensation. So who is that person? That government is? Who is the person that has ownership of these 100 acres?
My lord, we submit and rely on Article 237, but also Article 26, which provides that the land in Uganda can be either held individually or in association with others. And in this particular case, we submit that the government can compensate the Bachwezi because they own that land. Yes, my lord.
Council, but in this state, according to our facts under paragraph 14,
yes,
it's clearly stated that all rights of land, all rights to land are vested in government. So, are the Bachwezi not tenants of the government? And do they have any rights to this land?
My lord, Facts paragraph 14 indicates that the state alleges that all rights, all land, and the rights to land belong to the state. However, what the Constitution says is that the land is vested in the people. My lord, in the interest of time, I would like to request this honorable court to give me one more minute to proceed and submit on the applicant's prayers. Much obliged. In conclusion to issue 4, my lord, we submit that the question was in relation to paragraph 14 of the facts, which shows that the government has claimed that the land belongs to the people, to the state, and the applicant is submitting before this honorable court that according to Article 26 of the Constitution of Buranda, rather the land and property belongs to the people and not the government, and it can breach that right within the means and the acceptable means provided for under that particular article. My lords, in conclusion, would like this honorable court to in the interest that the government of Buranda has taken away the land of the Bachwezi people without consulting them and also without compensating them, which is a condition of the state of the Constitution, to find them in violation of the national legislation, regional and international instruments. And it is on the basis of the applicant's submissions in issues 1, 2, and 3, and 4, and 4 that we make the following prayers. This honorable court is vested with, it has powers to, under section 9, subsection 1 of, this honorable court is vested with powers to make orders where it deems appropriate, and these may include compensation. And accordingly, we pray to this honorable court that firstly, it declares that the mandatory vaccination of the adult refugees, adult persons in Buranda is a violation of the national legislation, regional and international instruments. Secondly, we pray that this honorable court orders the respondent state to provide vaccines or otherwise procure vaccines for its population. And thirdly, we pray before this honorable court that it declares that the restriction of refugees from entering its territory is a violation of the national legislation, regional and international instruments. And lastly, the applicant prays that this honorable court declares that the continued implementation of the standard gauge rail is a violation of the national legislation, regional and international instruments. And my lords, if the applicant is of no further indulgence to you.
Would you like an order pertaining to your clients getting back their land?
Would like this honorable court to order the respondent state to compensate or otherwise follow the Constitution.
Isn't 100 acres for 10 acres enough compensation?
My lords, we want to, the applicant submits before this honorable court that whereas the state has intentions or has declared that it can compensate, the Constitution requires it before even depriving of that land to compensate. And what we see in paragraph 14 of the facts is a state that has already implemented the project, which has displaced over 20 families without compensating the people. Yet this is a requirement of the Constitution.
His Lordship's question, would the compensation of the 100 acres that have already been identified be
Much obliged. The applicant rests his case.
May it please this court, my lords, for purposes of court record, my name is Muhindo Jason Mutunzi. Appearing for the respondent. And with permission of this court, my lords, I beg to proceed with issue 1. My lords, the crux, it is the respondent's submission, my lords, that it is the respondent's submission, my lords, that the government of Buranda did not violate the rights of her citizens by mandating the vaccination of the adult citizens. My lord, the crux of this matter rests on Article 44 and Article 43 of the Constitution. It is our submission that when the legislation was enacting this law, my lord, they had in their mind that at a certain point there would be rights that would be limited. We concede to the fact that Article 20 provides that the rights are inalienable and they're not provided by the government. However, the government must uphold the same. However, there are some circumstances under which, in the public interest, those rights can be limited and some rights can be derogated in that manner. I invite this court to look at Article 44 for that fact, which provides that some of the rights can be derogated, and Article 43 to that same, which says that some of the rights can be limited in matters of public interest. And I invite this court to scrutinize what amounts to matters of public interest. In this case, we are faced with a pandemic.
The applicant's submission is that mandatory vaccination amounts to a violation of Article 24 of the Constitution, and Article 24 is a non-derogable article. Could you respond to that?
It is our submission that it is not true that the right to non-concession to treatment is a non-derogable right. I invite this court to, in a persuasive manner, look at the Immunization Act of 2017, which was enacted purposely to mandate the...
Of which country?
It is, my lords, it is a law for Uganda, but it is pari materia with the laws of Buranda. I invite this court to use it as persuasive in this manner, to look at the reasons why the legislature had to mandate the vaccination of children. In this regard, I also invite this court to look at Article 21, which provides for...
Counsel, you can't just leave this court with homework. Why did the legislature mandate vaccination of children in the act you referred to? Do you have a copy of the Ugandan Hansard to back up your submission?
With the leave of court, I can hand it to you, my lords. However, I proceed to answer that question, my lords, that it was within the minds of the legislature that there comes a point where mandatory vaccination has to be effected. And when you consider Article 21, the right to non-discrimination, it is erroneous to claim that children are less human beings compared to adults. If children can be mandated to take that vaccination, how about adults?
Immunization Act doesn't relate to COVID-19 vaccines. It's vaccines of a whole other list of diseases. So we will not consider it in that regard. Do you have another argument?
My lords, I really invite this court to look into that, because whereas COVID-19 vaccines are quite different, but they're all categorized as vaccines, and they answer an aspect where the country is faced with a pandemic. And so it has been tested that indeed vaccines are a measure that can combat such kind of a pandemic. I invite this court to look at the case, the Supreme Court case of Brazil, which was faced with the same facts as to whether it is constitutional for for government to mandate the vaccination of her citizens. In that case, it was held that it is not unconstitutional as long as the parameters are fulfilled. But the main crux of that is that it is not unconstitutional to the effect that it is one of the rights that can be limited in that regard.
Counsel, what were these parameters in this case?
The parameters, my lords, were efficacy, the safety of the vaccine, the proportionality, and the availability of the vaccine or in supply of the same. And so it is my submission that the applicants have not satisfied this court that the vaccine they are challenging has not met the same. Subject to Section 101 of the Evidence Act.
The applicant's other submission is that mandatory vaccination that has a criminal sanction attached to it is not proportional. It's not proportional to the right that you seek to protect, and it's not demonstrably justifiable in a free and democratic society. It seems the Immunization Act you're referring to supports the applicant's submission, because Section 3 only provides for parents to ensure that their children are vaccinated. There is no criminal sanction to it. So if you were inspired by the Republic of Uganda, why didn't you enact a similar provision, but instead place criminal sanctions?
My lords, I invite this court to look at the rationale behind Article 22, which provides for the right to life. In as much as the right to life is provided for, it can be taken away. Vaccination is a lesser thing to the right to life that can be taken away under some circumstances. I invite this court to take into regard the fact that this mandatory vaccination has been brought for public interest, in the matter of public interest, which supersedes any other interest of an individual. And in this regard, I invite this court to find that indeed the government did not violate.
I'm sorry, Attorney General, you are misleading this court. Article 22 only allows for derogation from the right to life in respect of criminal punishment. So you're saying you want to take away your citizens' right to life? Is that what you mean? Your submission isn't making sense.
My lords, that is not our submission. Our submission is candid on the fact that which right can be taken away, which right can be limited, which right can be derogated. And it is our submission that the right to non-concession does not fall under those rights that are non-derogable. Neither does it meet the aspects that are provided for under Article 43, which provides for the limitation, and the most important being that it can be limited in matters of public interest. I beg to submit on issue to my lords. My lords, we invite this court to find that the non-provision of vaccines to the people of Buranda was not a violation of their rights, owing to the circumstances that the government of Buranda operates. My lords, according to the facts, it is evident that this is a low-developing country. It is a country that is limited of resources, and so there has to be priority that should be taken in allocation of such resources. My lord, I invite you to look at the African Commission in its principles and guidelines under progressive realization of resources, where it was held that in as much as the government progressive realization of resources. Yes, it was said that much as the governments have that mandate to provide resources such as health, such as education and the others, but it should be within the ambit or the limit of its resources as well. I have already highlighted that according to the facts, Buranda is such a developing country which is constrained, and so it is evidenced by its budget allocation. In that regard, we invite court to find that there was proper allocation, albeit it not being enough for all citizens. My lords?
Buranda is an African nation. African states have since 2001 committed to allocate 15% of their budgets, according to the Abuja Declaration, 15% of their budgets to health. You have only allocated 3%, and even when you had the opportunity midway the pandemic to up your budget in the next financial year, nothing was done. Is that really progressive realization?
My lords, I invite this court to get in touch with the reality and come to know that indeed Buranda is a developing country. In all aspects, this country is limited of resources.
That is not denied. That we do not deny that. However, even if your national coffers only come down to $2 million, if you're only assigning 3% of that $2 million time and time again, it shows that you're not committed to assigning any more. So how about if you showed us that next year you will assign 4% and the next 5%, there is some type of increment in making sure that you provide for the right to health of your citizens within your means. My question is that the way things are in your nation, it seems like there is no progressive realization at all.
My lord, I invite this court to take cognizance of the fact that Buranda is in a volatile region, this region that is engulfed in wars, and its neighbors are always in wars, such that it has received a lot of refugees into Buranda, and its security is at stake. To this regard, about 4 months ago, Buranda experienced explosives from terrorists. This is one thing that Buranda is actually looking at, beefing its security. My lords, whereas it is not indicated in the paragraphs here, but I invite court to take it as judicial.
Counsel, stick to the facts.
Thank you for your guidance, my lord. However, I invite my lords, to take account these facts which state that indeed Buranda is in a volatile region, which region has its neighbors facing wars and here and there. That's why we have a lot of neighbors coming in. And due to that fact, and being in that volatile region, we invite this court to find that beefing up security is one of those areas where the country's resources should go, other than just leaving the country at the mercies of God. My lord, in the interest of time, I invite my co-counsel to proceed with issues 3 and 4. Most of that.
May it please this court, my lords. For the purposes of court record, I'm Shakila Singoma Samuel. And I'm proceeding on issue number 3 and issue number 4. As they already said it to us, issue number 3 was regarding the refoulement of refugees according to the way they were averring. My lords, it's our submission that Buranda as a republic, Buranda as a country have not stopped admitting refugees. We have only put a limitation on their entry, looking at our economic situations and the current situation we're in. My lords, it's our submission that if we consider Article 4 of the International Convention on Civil and Political Rights, which brings about the idea of derogation of powers under emergency situations, COVID-19 came to us as a nation when we had not prepared for it. And in this situation, when we're having an emergency like this, the most appropriate thing that we would do would suspend some of our international obligations in order to protect the masses that we're having here. That one evolved that the refugees at the borders should be tested if they are positive or negative. If they are negative, they are allowed to enter into the country.
So why didn't your country borrow a leaf from other African nations like Uganda? It continued taking in refugees even in the midst of a pandemic, and refugees who were found to be COVID-19 positive were instead quarantined but were not referred back to a place where their lives would be endangered.
Much obliged, my lords. Even when we would borrow a leaf from the neighboring country like Uganda, we are not the same of economic status. Even Uganda itself, it's reported via media outlets that during that pandemic, the refugees in their various camps were not getting adequate resources. So for us...
Counsel?
Yes?
Media reports are not an authority in the court. Find another authority to base your submissions on.
Thank you very much, my lord. What we are saying is we would have borrowed from them, but looking at our own status as a country, where we cannot sustain them, as we have bringing about the concept of progressive realization of resources, us bringing them to add pressure on the already weakened health sector, weakened economy, it would be bad for us. We're not saying that the refugees should not come, but we are trying to relieve ourselves in such an emergency situation. This is a thing we had not budgeted for. And my lords, when we allow these people in our nation, we are not actually solving anything, because themselves, they will come, the resources will not be enough, and our own people. And as a nation, according to our national objectives, the state will always prioritize its own people. The state, as a sovereign state, will always have that thing. We take our consideration most, then international comes in such an emergency situation. We shall not say that we're infringing on the freedoms of the refugees, because these people, after all, we are stopping them at the border. They have not yet even entered. We are only taking a few that would require, because we are already pushed down.
Counsel, I do not buy your submission, because Article 35 of the UN Convention on Refugees gives you a ready solution, in that if you're finding difficulty enforcing your obligations under that convention, you can call upon the assistance of the United Human Rights Commission for Refugees. Did you do that?
Much obliged, my lord. Even if we call at the UNHCR to come and help us to calm down the situation, we know that the aid itself comes with the strings attached, and in such a situation, my lords, it was not going to be very, very appropriate. Already we are hustling with a high number of refugees in our country that we are taking in. And
Counsel, is the issue the number of refugees or them coming in already infected with COVID?
My lords, the issue is them coming in when they are already affected. But we're saying if we add those ones who are already affected and those ones who are not affected, we add it to the number of people we're already having in the country. And yet our economy is not doing well. Our health sector is not doing well. It's harm to us. At the same time, we are not able to manage the requirements of these people as a nation, and our people are going to be at stake. But when we say, let's allow a few of them to come, we have not suspended their rights to the fullest. What we're saying, let those also have managed, let's have them according to our resources, so that we can prepare for this. My lords, I also beg to submit on issue 4, if it may please the court. That regards the implementation of the CJR project. My lords, the government is vested with the powers to plan and to promote anything related to national development. The construction of the railway itself is for the benefits of the entire nation, of the entire country. Branda itself, even the Bachos people themselves. What the government here is saying, that when we are implementing this project, like how the minister is averring, it's to foster development in this area. However,
why the applicants have submitted that Article 26 mandates the government to provide adequate compensation before taking away anyone's right to property in public interest. Did you provide them with adequate compensation?
Much obliged, my lords. Actually, from the facts themselves, under Article 12, from the facts themselves, the people of Branda, ab initio, rejected to negotiate with us. They opposed the construction of this thing even before we made negotiation with them.
Where did you get that from?
It's,
Because Article 13 says otherwise. Paragraph 13, rather.
I'm saying, it's paragraph 12.
Where? Which line?
Which line? First line and second line.
What?
The virtuous people have opposed the project since the inception and fear that this project will lead to destruction of indigenous forests where traditional healers living within the area find plants used for medicine while others residents use the land for grazing their cows, fishing, and growing spinach as well as banana trees.
Is that the same as saying that we have that the Bachwezi people have refused to negotiate with the government? It's just saying that the Bachwezi people are opposed to the project because it threatens their lives as indigenous people. It's different from them refusing to come to the table to negotiate. If anything, their leader in paragraph 13 says that government failed to consult and obtain consent from the Bachwezi people. So you never wrote to them, invited them to any type of negotiation.
Much obliged, my lords. Our position is on this. Them opposing the system, it means we did not come to ecosystems. When they opposed it, we did not come to ecosystems. So in such a situation where they were objecting, my lord, we did not deem it fit that even they continued ahead to say this because we as the government were believing that we're going to compensate them with 100 hectares. We relocate them to 100 hectares from the 10 hectares. As we do this, we had already followed the right procedures.
There are already 20 families that have been displaced. Have these been relocated?
Much obliged, my lords. The people that were displaced, the 20 families, they were not displaced by the state. They were the floods that displaced them. It's not the state.
Floods a result of construction.
Yeah, as a result of construction. But meanwhile, negotiations were still going on. Because
negotiations are happening, but as you're saying, but construction is ongoing, right?
Yes.
Then what type of negotiations are those?
Oh, much obliged, my lord. The laws of Branda really provide, actually, according to the facts, it's a privilege for them to own land at large. It's not a right. And Article 272 places such forested areas in the hands of the government. And in some situations where it's matter of national interest.
Sorry, which article?
Repeat
that submission.
Article 273. 237, rather. So, my lords, in such things when it's vested in the hands of the government, these people, and government has the mandate to acquire land compulsorily. But these people, because as long as it's in matters of national interest, my lords, I would like to invite this court to the matter of Katamba versus UNRWA.
Please don't go any further. What makes the Bachwezi people's land, such land that's vested in the government? Is it a wetland, a forest reserve, a game reserve? Where in the facts does it say that it meets the type of land described in Article 237 2B?
Oh, much obliged, my lords. The facts clearly said that actually, if we go to to paragraph 12 of the same facts, the indigenous forests where traditional healers are living within this. The forests themselves are natural resources.
But is it a forest reserve? There is a forest, and then there's a forest reserve. It being a forest reserve means it's a gazetted area. So, help me understand how their land qualifies as the type of land described under Article 237 2B.
Much obliged, my lord. It's our submission that we well know that human rights are not absolute. And in some situations, they can be taken away for the greater interest. They're mentioning the forest. Indeed, they have not clearly showed to us whether it's a a forest reserve, all this. But it doesn't remove the fact that they remain natural resources.
No, they are not natural resources. It's communally owned and used land. It's not land that's owned by the government. Your constitution allows for customary ownership of land. According to their customs and norms, they can own this land in line with the constitution as a group. So do you want to abandon your argument? Your rather ingenuous argument.
Much obliged, my lord. I'm only twisting the argument. My lords, even when we have communal system, we're saying under Article 26, and still this, if it's in matters of national interest, the government can use the land, and when we talk of public interest, we are meaning for the greater good of the people. We're not only considering the Wachwez people themselves. Branda is too big and it accommodates other tribes rather than these ones. What we're saying that we're acquiring it for the greater good for them. According to the facts, we're saying it will boost their economy to help them, their development. Only that negotiations have not gone well because these people, we have failed to come to a consensus together. And government thus can acquire land compulsorily. Because we promised to compensate them, and these people opposed it.
Could you comment on the government's obligation to develop its country versus the rights of indigenous people, and if you have put into consideration the rights of these indigenous people?
Much obliged, my lord. We know that the Wachwez indigenous people who have lived in this country over the 80s, and they are the people who are supposed to protect them. International law recognizes that, and everything recognizes that. But my lord, our submission is that even when they are indigenous people, in our submission, they are not the only indigenous people in this country. There are some other indigenous people, and we are doing this one for the greater good. My lords, the construction of the railway, we're not taking...
What is an indigenous group in the law? Because it's not the same as a tribe.
Yes. Actually, Article 10 of the 1995 Constitution of Buranda tries to cater for who would be the indigenous people. I need guidance on that if I've had in law. But the position of the law is that regarding the indigenous people, is that these people have been here before 1962, before February of 1962, are regarded as indigenous people of that particular nation. It does not whittle out the view that they are people from Buranda, them being indigenous. And everything the government is doing it in line with these other people. So if they have their customs as indigenous people that will not allow them to use their thing, and it seems to be repugnant with the entire, with what the other people believe in, then that thing, then their culture becomes null and void. Only what we're saying, we have recognized their rights, because if we had not recognized their rights as a state, we would have relocated them a long time ago. 1 minute, my lords, I request. Yeah. My lord, we make these prayers majorly on two grounds. We say that on issue number 3, on issue number 4, the government, the court should declare that they should follow, rather should call the Wachwez people and the state to come to a consensus for negotiations so that we can successfully relocate them. Because the moment we push this one out, the project will not stand. Then on issue number 4, we pray that, rather that was on issue number 3. Then on issue number 3, we do pray that, my lords, we have to dismiss this matter, because we are a sovereign state and we are poor. We may not sustain them in this situation, and we have a right to derogate our powers in such. May it please this court, I raise my case.
Much obliged, my lords. We had reserved 3 minutes for rebuttal. In rebuttal, it is the applicant's submission that the state of Buranda violated its obligations enshrined in national, regional, and international human rights instruments when it enacted mandatory vaccination law for all adult citizens. The Attorney General has submitted that the mandatory vaccination law of all adult citizens was in protection of the right to life. However, the right to life can only be derogated from when it comes to criminal matters, that is, penalties that take away the life of the people. Also, the Attorney General has not demonstrated to us how the mandatory vaccination law passes the limitation test that is provided under Article 43 of the Constitution of Buranda, despite the fact that he has hinted on it, but he has not demonstrated to us how the mandatory vaccination law passes this three proportionality test that was established in Charles Onyango-Obo versus another Vice Attorney General. Also on issue 1, the Attorney General has submitted that mandatory vaccination law has been enacted in other countries such as Brazil. And the case he cited set out some parameters. However, the Attorney General has not explained to this Honorable Court these parameters and how they have been met when it comes to the case of Buranda. On issue 2, the Attorney General submitted that the state of Buranda is a low-income country and has other pressing needs, such as the security threat. However, it is our submission as applicants that the priority should be given to the health threat and not the security or war threat, because the facts guide us and give us a fatality rate or the extent to which this health crisis is a problem. However, apart from the Executive Prime Minister addressing the public and saying that there is a security threat, and if more budgetary allocation is given to the health sector, there will be terrorism attacks, we are not seeing any facts that support this claim. The Attorney General is mandated, and the Respondent state is mandated to give us these facts to show that indeed there is a looming security threat. It is the submission of the applicant that in the facts we have seen that 1 million people have died, leaving the population with 5 million people, and yet more than half, that is 3 million people, are already infected with the virus. On issue 3, the non-refoulement is a submission of the applicant that the non-refoulement is use cogents and international customary law. Much obliged. It is the prayer that this application is considered.
My lords, with your permission, I'll use a few minutes to rebut. About 5 minutes, my lord. Not really, my lord. I seek for your guidance, my lord, on that, but to the best of my recollection, I reserved some minutes for that. Most obliged, my lord. I am going to rebut on the issue that concerns the Bachus as indigenous people, and whether being...
Counsel, limit your submissions to what has just been stated in rebuttal.
Thank you for
in general.
Thank you for your guidance, my lord. The applicant contend that we have not shown them whether the vaccine is it bears the regulations that have been put forth by the World Health Organization in terms of its efficacy, in terms of safety, and the others. My lord, it is straight law that he who alleges must prove. For us, we've made our case, and if the applicants think that indeed the vaccine has not met the trials, it is up to them to produce evidence to that effect. As far as we know, the applicants have not made the same to this honorable court, my lord. And lastly, on the matter of security, it is our contention that security is a national issue. However, security should be a preserve of the executive, and that we have the mandate to either release information concerning the terrorists or not. In that regard, giving our information concerning security to the public would put the public to panic. I beg to invite this court to find that indeed security is a national issue which should be taken into consideration when the country is allocating its resources to justify the reason why we allocated it as such. Most obliged.
The first one, Shakila, S-H-A-K-I-L-A-H. Then the next one is Singoma, which is S-I-N-G-O-M-A, Singoma. Then then Samuel is the local language. It's S-A-M-W-E-L-I. Thank you, my lord. W-E-L-I. We are Team H.
Thank you for all that have participated. You've put up very convincing arguments, and you've all done well. So now we are going to score you. We have been writing aside remarks that we are going to base on to score you. But generally, you have all done well. We had already given you remarks earlier at the terrace, and we have noticed that most of the things that were said, people have tried to consider them in their submissions, and we noticed that there's been some good improvement in this round. So
thank you all for taking part. This has been the best round I have had so far. So I guess things are really improving and you deserve to be here. My general comment for all of you is to mind your language and your phrasing. It attracts a lot of questions. Some of you are saying, no, most of you are giving statements that are not founded in law, but out of respect for your time, I tried not to over-engage you. I mean, or you made statements that do not, you just strung words together that do not make any point. So listen to yourself even as you speak so that you're not overtaken by the emotions of the moment. My other comment for all of you is to respect court decorum and just mind the language that you use. Otherwise, I loved the fight that was in all of you. I enjoyed the engagement with the bench, and I appreciate the fact that you took time to understand the facts of the case. All the best to, I guess, whoever makes it to the final. See you then. You may sit. Good evening, everyone. Welcome to the final round of this moot court competition. Congratulations to the applicant and respondent team, and best of luck. You each have 30 minutes. Use your time wisely. We will be hesitant to add you extra time. And also state your names slowly, and so that we are able to record them, and give us your time allocation before you proceed. Thank you. You may start.
Much obliged, my lords. My lords, my name is Blessed Atwine Mucha, the Attorney General representing the state of Buranda, and I appear with my co-counsel, the Deputy Attorney General, Nicholas Najuna. We represent the respondent state of Buranda. And the applicants are represented by Counsel Muhindo Jason Mutunzi and Counsel Shakeli Singoma Samuel. With leave of court, I beg that the applicant may proceed with submissions.
May it please this honorable court, for purposes of court record, once again, my name is Muhindo Jason Mutunzi, the lead counsel for the applicant. My lords, if you may permit me to take this court through the brief facts in issue. The facts are that Buranda is a low-developing country which has been hit hard with COVID-19. It has a population of 6 million people, and 3 million people of them are already affected with the COVID-19 disease, and 1 million have succumbed to the same. Buranda admits refugees because the area is volatile. However, in the wake of COVID-19, it has put restrictions on the same, to the effect that refugees who are admitted must either be fully vaccinated or take a mandatory test at their own cost, which is to the tune of $25 US. In that, if they do not take the same, they are returned to their countries of origin. Also, Buranda is having its plans of constructing the SGR, that is standard gauge railway, and to this effect, it has encroached on the land of the Bachwezi, the indigenous people. My lords, if you may permit me to delve into issues 1 and 2. And before I proceed, my lords, I am going to use 15 minutes of our time allocation, and my co-counsel will use 15 minutes of the time allocation. If you may permit me to proceed.
You reserve no time for rebuttal.
Thank you. Thank you for your guidance, my lords. I amend our request, and to that effect, we reserve the 5 minutes for rebuttal. To that effect, I'm going to use 15 minutes. My co-counsel will use 10 minutes and reserve the 5 for the rebuttal. Most obliged. The first issue before this court is whether the mandatory vaccination of its citizens is a violation of Buranda's obligation enshrined in the national, regional, and international instruments. It is our submission as the applicants that indeed the mandatory vaccination of the citizens is a violation of their inherent right that is provided for under Article 20, which the state does not guarantee but has to uphold. I invite this court to look into the rights that are non-derogable and the rights that might be limited in that regard. A right to health, beg your pardon, my lords, the mandatory vaccination of citizens in its sense amounts to cruel and human treatment of the people, in a sense that if the citizens have not consented to taking this kind of vaccine, which they do not know whether it is safe for their bodies, whether it is even effective, it may bring of kind of psychological torture, which is one form of torture that is preserved under Article 44, that it shall never be taken away. Citizens shall never be subjected to that kind of inhuman treatment,
Counsel,
torture inclusive.
the Convention Against Torture, which you are a party to, defines torture as any means by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him information or a confession, and then it gives a whole host of issues. So are you saying a vaccine that's just a needle prick is intense and severe pain?
My lords, it is not just about the needle prick, it is about the resultant of the vaccine itself. When you think about what the vaccine will do to your body, it may bring that kind of psychological torture. You will not be emotionally stable. And so this, in effect, might bring the aspect of torture which the Constitution has prohibited at whatever cost. My lords, it is our contention that we concede that actually the country can go forth and force its citizens to carry out mandatory vaccination, but that vaccine must have met the trials. For instance, in the case of, in the Brazilian case.
What do you base it on? That vaccine must have met trials. And what do you mean by trials?
My lord, according to the COVID-19 mandatory vaccination ethical considerations and CAVIT's policy brief that was put out on 13th of April 2021 by the World Health Organization, it took cognizance of the fact that some nations or countries might think of mandating vaccination. However, it put out guidelines that must be followed to ensure that that vaccine meets some kind of efficacy, that it should be safe, that it should be the only way, and that it should be in supply. The facts reveal that Buranda itself got a donation of 500,000 doses. And when they were done, it actually asked COVAX to avail more of the vaccines, but there were no more. And instead of procuring its own, it did not have enough resources. And to this regard, there should be no reason as to why, if Buranda cannot buy its own vaccines, it should mandate the same. In fact, it has not only mandated vaccination, but has gone ahead to impose sanctions that when one refuses to take a mandate, then they will be culpable for that. In that regard, if the vaccines are not there, and these people are subjected to that kind of treatment, we believe it has not met the total criteria under which a mandatory vaccination should be imposed on the people of Buranda. My lords.
Council, are there any other countries that have come up with vaccine mandates?
Yes, my lord. Kenya, for example, a neighbor to Buranda, has come up with mandatory vaccination. However, it has not met the test. People have not impressed the same. And so from that regard, we don't think it is quite enough to mandate the vaccination. Tanzania itself has reluctantly failed to do the same because mandatory vaccination is almost serving no purpose. However, if I can invite this court to look into the case, the Supreme Court of Brazil case, where the case was met with the same facts as to whether the government had enacted mandatory vaccination, albeit it being to a certain section of people. Like if you're not vaccinated, you will not access health units or schools and so forth, which was a limitation to that. But court went ahead and said it is not unconstitutional for as long as government can truly provide evidence that the vaccines they intend to impose onto their citizens, the vaccines are safe, they are efficient and effective, and to that effect, this court finds it that since the government has not come up with the same measures, this court should declare that that program should come to a halt.
Counsel, so are you questioning the integrity of the vaccine, or you're questioning the vaccine mandate in lieu of those requirements you have stated from the Brazilian case? Is the integrity of the vaccine in issue?
Most of blood, my lords, it is our submission that indeed integrity of the vaccine should be taken into account, because it is being taken by people and people must embrace the same. It is these people that will be subjected to that vaccine. If they do not embrace the vaccine to be one of the measures that will end COVID vaccine, some of them will hide from being mandatorily
Is a
vaccinated.
WHO guideline that people must embrace it, or it must be proved as one of the preventative measures?
My lords,
because are we running a socialist policy that if people don't embrace a policy, then it shouldn't be there in the first place? Or we have to look at the policy's efficacy?
My lords, if I invite you to look at Article 287, which embodies or enjoins the government of Buranda to respect international conventions, which they are party to. In our submission...
You're not answering the question, and also that article provides for international conventions, of which the WHO guidelines you submitted are not a convention, i.e. there is no representative of Buranda that went and signed on to it. But back to the question, should we consider whether the public has embraced the policy, or we should look at the efficacy of the policy?
My lords, we are looking at the right of the citizens that they have, which is concessional to medical vaccines or treatment, which is invaluable. And in that regard, I invite this court to take cognizance of the fact that this right, if it has not proved that the vaccines will surely contain COVID-19, this court should declare that program should make further research to ensure that the vaccine that they're about to make mandatory to its citizens fulfills all the required medical trials, my lord. My lords, if you may permit me to submit on issue number 2. Issue number 2 is to the effect that the government of Buranda has failed to procure enough vaccines for its people, thereby violating their rights to access to medical health. My lords, I invite this court, to declare that indeed the government, which has been mandated on behalf of the people to protect them, and in such kind of a pandemic, they failed to provide the vaccines that could combat this COVID-19, is their violation as a people. My lords, the African Commission...
Counsel, from the facts, are there any steps that have been taken by the state of Buranda?
Thank you, my lords. True, we concede that there are some steps that have been taken by Buranda. For instance, it declared the lockdown. It also provided that citizens can put on masks, and also acquired 500 doses of vaccines for this matter. But the donation came from COVAX. It was not a government's initiative to provide such kind of vaccines to its people. In the facts, it is indicated that indeed this government, the chunk of its budget goes to security. Only 3%, barely 3% goes. That is about 15%. It's about 25%, 1,000,006. Yeah, they're about 20, 25%. However, according to the Abuja Declaration of 2001, it was held that at least, much as African countries have limited resources, they should reserve 15% of their budget towards
Did Buranda
health.
sign on to the Abuja Declaration? And if not, what is the value of that authority to this court?
Pardon, my lord?
Did Buranda sign on to the Abuja Declaration? And if not, what is the value of that authority to this court?
My lord, Buranda is a signatory to the Organization of African Unity, which is now African Union, and to the best of my collection, it ratified the same, and Article 287 provides that those conventions to which Buranda ratified prior to the coming into existence of the 1995 Constitution shall be upheld and shall be taken, that Buranda or the current Constitution ratifies the same.
You haven't answered the question. The Abuja Declaration is simply that, a declaration. It's not a convention, and so you can't infer Buranda's membership to the AU to mean that they also signed on to this declaration.
Most obliged, my lord.
So where in the facts does it say that it signed on to the Abuja Declaration of 2001?
Most obliged, my lord. I beg to abandon that, but still proceed with the African Commission in its principles and guidelines under the doctrine of progressive realization of resources. This is a doctrine under which countries like Buranda, which are low developing, must take reasonable and necessary steps. We have to, I invite this court to look at critically the word reasonable and measurable plan. In our view as applicants, submitting the citizens, pardon, in our submission as applicants, my lords, I invite you to look into this, whether indeed 3% of the budget being allocated to procuring of vaccines or to the health budget is indeed reasonable in the wake of a pandemic that has claimed 1 million people and 3 million people are sick. We do not know the fate of the 2 million people that are remaining. And so if it cannot provide the same vaccines, it is not reasonable enough as envisaged by the doctrine of...
But again, counsel, this court does not formulate policy. And even if we gave you the order that you want, we are not going to come and enforce it. It is still the state to enforce. What do you think about that?
My lords, my time is up. But to answer your question, I beg for 2 minutes.
Question, and maybe to add on to that very same question, what would be a more appropriate order? Like, do you want us to order for the state to provide another 500,000 vaccines? What type of order are you realistically seeking from this court that doesn't enact policy?
My lord, the same courts in Buranda have addressed their minds on the same issue as in the case of Sihad versus...
So I'll stop you right there. Sihad is a case before the Ugandan courts. You are in Buranda. Just because you have a similar constitution does not mean that this court is the same as a Ugandan court.
My lord, it is my submission that it is a persuasive case which I am making, and it is up to you, my lords, to consider the rationale that was expounded in that case, that inasmuch as the government is constrained as being a low developing country, it has to take all the reasonable steps. And that court directed the government to procure the same. The government was faced with insufficient medical supplies to the women, and so CIHAD, as an organization under public interest litigation, moved to court to provide remedy to this obligation that the government of Rwanda had not undertaken when its people were languishing.
Thank you, Counsel. Thank you. I think we get your submission. Please yield the floor to your
Most
co-counsel.
obliged.
May it please the court. May it please the court. I'm proceeding on issue 3 and issue 4. Proceeding on issue 3 and issue 4 in this matter. My Lord, issue 3 is whether the restriction of refugee entry into Burundy is a violation of obligations enshrined in national legislation, regional and international human rights instruments. My Lord, Rwanda is a signatory to most of these international human rights laws and conventions that the Vienna Convention of 1951, the UDHR, among others. My Lords, it being a signatory, there is a principle that says if a country is a signatory to that treaty, it must observe in good faith and follow what has been stipulated.
Where is that principle?
Oh, thank you very much, my Lord. The principle is called Pacta Sunt Servanda, which...
Okay, the language of this court is English. Where do we find this principle?
We find the principle in the Vienna Convention and its preamble.
Which one? Please state the full law.
Okay, my Lord. My Lord, in the preamble of the Vienna Convention, they do describe how this thing should be followed, that same principle. In that,
Counsel, if a country signs, does it become bound by a treaty? Mere signing? Is it enough for it to be bound by the treaty obligations therein?
I beg your pardon? Okay, I change. Of the Vienna Convention, and Article 26 of the Vienna Convention is the one that really provides for this. And other international human rights bodies...
No, Her Lordship asked you a question. If a country signs, merely signs onto a treaty, does that mean it's bound by it?
Much obliged, my Lord. Article 287 of the Burundian Constitution provides that on those things that we're signatory to, on those treaties, we have to observe them. However, if we just sign and we not commit ourselves to them, we may not become part of it. But here, we signed to them as Burunda, and we're signatory to them, so we must observe this principle.
What do you mean when we don't commit to them? Is there another step after signing, and what is that step?
Much obliged, my Lord. Actually, you'll observe that when these international instruments are coming to an end, there is always a declaration. Different states that are party to it commit themselves to it, and they sign on that particular document.
In the facts, it states that Buranda is a dualist state. What does that mean in relation to how international conventions bind it?
Talking of Buranda as a dualist state, it means we do observe our domestic laws, and at the same time we do observe the other ones. But due to the principle of...
Council, that's wrong. You will address your mind on the principle of duality in international law. Carry on with your submission.
Much obliged, my lord. So, in such a situation where ourselves, we have committed ourselves to this and we cannot observe them, it's a violation of their rights because human rights are inalienable.
Council, just still on the issue of signing, could you please guide this court on the difference between signing and ratifying an international treaty?
Most obliged, my lord, if you may permit me to address my mind on that as co-counsel. The difference between signing and ratifying is that when you sign, it remains in that convention, but when you ratify the same, then it is domesticated in domestic legislation. I beg to submit.
Am I bound if I simply sign?
Come again, counsel. So, my lord.
If a state stops at signing, is it still bound?
My lords, if we address our minds to Article 287, Clause 2, it categorically states that the convention shall be upheld by this state of Buranda. In other words, they have ratified their efficacy.
Time. Just answer yes or no. If you merely sign, are you still bound? Yes or no? It's a simple question so that your co-counsel can carry on with his submission.
Say yes, most obliged.
My landed colleague, thank you very much. My lords, proceeding on the same. So we shall find that something, the doctrine of non-refoulement will apply in this situation, where we say if a person is sent to the state where he's likely to face torture, arbitrary arrest, and any other kind of human activities done on that person, this person should not be taken back. It means sending back the refugees to the countries where they're running from. Actually, it's not only illegal, it's also immoral. In a situation where your neighbor says, my house is burning, and you see your neighbor coming to you when the house is burning, and then you say, you go back, you have not put on the shirt. My lord, in this situation, it really doesn't show the humanity we have as individuals. In this situation, we're saying, even when we have COVID-19, it's harming our people. There are other ways the government that can adopt their alternatives in getting these refugees. For instance, we have observed that the use of face masks, social distance, and observing all the other SOPs can help to fight such a disease. History has proven it that even in the periods, history has showed it that in the period when we had SARS like MERS, smallpox, still observing such SOPs worked better. Rather than restricting them from not coming, we can get those refugees who quarantine them, those ones who test positive, and we put them in that particular place. The state would have used that, but which they did not work out, but instead they went ahead to block them. My lords, if it may please you, let me proceed to issue number 4. On issue number 4, the issue number 4 concerns the implementation of the standard gauge railway. My lord, it's the role of the state to ensure that these things are put in place. However, the formula that they adopted does not really match what they ought to have done. These people had already constructed the standard gauge railway without prior compensation to the people. Article 26 of the 1995 Constitution of Buranda says when the government is to do such, it must pay prompt payments to them, compensation, prior to the implementation of such a project, which the state did not do in such a situation. What they only did, they promised They promised them they had already gone ahead with
Council, but in the facts they state that the Bachwezi have been violently demonstrating. So how do you expect the state to compensate them when the Bachwezi have been violently demonstrating?
Much obliged, my lord. The Bachwezi violently reacted to this, opposed this, because these people have already gone ahead with the construction. That's why we're seeing even the displacement of some people due to the construction works. They are doing this, meanwhile they're implementing this, but they're supposed to develop the roads when they have compensated people. The case of Unura versus Asumani Irumba is our authority on this, where a court declared that Article 7.1 of the Land Acquisition Act was inconsistent because for it required the government to compensate people even when it has taken the land. But the Constitution says otherwise. So in this situation, that's
Council.
what they are trying to do.
Council, now in case of an impasse, in case the Bachwezi and government fail to reach an agreement, what is then supposed to happen?
Much obliged, my lord. When they fail to take to reach an agreement, and it's a matter of public interest, what the state is going to do, we're going to proceed with the construction, and we put what was supposed to compensate them. Either we save that money with the court, we save that money with the court that would purchase the hectares, because we have nothing to do, because the law is very clear.
So you agree there are scenarios where construction can go ahead without compensation?
Yes, we do believe there are those scenarios, but the Bachwezi have not refused. The government had already gone ahead to do what it was doing. Yeah. They constructed prior to compensation instead of compensation prior to construction. Yes. Much obliged, my lord. The case is Unura versus Asumani Irumba. It guides that the government has to... the facts in that case, when they were constructing the Mukono Katosi Road, when they were constructing the Mukono Katosi Road, my lords, the government had to evacuate Francis Irumba, who was also standing in for his people, without compensating them. So Irumba was like, the government was basing on Article 7.1 of the...
And so please mind your language in court.
My lords, what Francis Irumba was standing on, the thing was the government was already constructing, and they were relying on to have used proportionate and reasonable ideas. The indigenous people, under Article 11 still, it goes ahead to explain who they are. They have a right to practice and revitalize their culture, which we cannot stop. My Lord, our prayer regarding issue 3 and all other issues, we pray that this honorable court grant the petition the following prayers: a declaration that mandatory vaccination of citizens in Branda is a violation of their right to health and life; a declaration that the government failure to procure the vaccines is in violation of its national obligations; an order to issue for the purchase of vaccines; an order for the issue of the halt to the SCJR project; and a declaration of the government action of restricting refugees from entering Branda to be declared inconsistent with its other laws, that they should admit them but provide other alternatives.
Thank you. Thank you, Council.
Much obliged, my lord.
We'll now hear from the respondents.
If it may please this honorable court, my name is Blessed Atwine Mucha, and I represent the respondent state in the capacity of Attorney General, together with my co-counsel, the Land Deputy Attorney General, Nicholas Najuna. We shall use 30 minutes of this honorable court's time to respond to the applicant's submissions on the issues in this matter. I will use 15 minutes to respond to applicant's submissions on issue 1 and 2. The Land Deputy Attorney General will use 15 minutes to respond to the applicant's submissions on issue 3 and 4, and as well make prayers for the respondent. We respectfully reserve no time for rebuttal. Issue 1 deals with mandatory vaccination law of all adult citizens of Buranda, and whether this is a violation of Buranda's obligations enshrined in national, regional, and international human rights instruments. It is the position of the respondent state that the mandatory vaccination law does not violate Buranda's obligations enshrined in national, regional, and international human rights instruments. The facts in this case are that Buranda was hit with the COVID-19 pandemic in 2020, January. And with the rate of spread of the coronavirus, 1 million people out of the 6 have unfortunately perished. 3 million people have succumbed already to COVID-19, leaving the population unaffected of only 2 million people. My lords, this is a health crisis in the state of Buranda. And the government of Buranda, which is mandated to protect the right to health of its citizens, has to take a step to ensure that it protects this right to health. My lord, the World Health Organization has advised that vaccination is a key measure, an important measure in the prevention of the spread of infectious diseases, in this case, the COVID-19 pandemic. And my lords, with the statistics of infection in Buranda, the government of Buranda has taken a step to enact a law on mandatory vaccination of all adult citizens as we await reception of vaccines. My lords, the applicant submits...
Counsel, if I may question you about that law, was it absolutely necessary and proportionate for you to attach a criminal sanction?
My lords, it is the submission of the respondent state that whereas criminal sanctions may appear to be disproportionate, they are not, or they should not be found to be disproportionate. Because, my lords, there are ways through which these criminal sanctions can be avoided. My lords, we submit that the penalty for not submitting to mandatory vaccination is two-way. It is an administrative fine of $360 or imprisonment for 6 months. My lord, the courts of law in this land have the power to sentence anyone that has been found in violation of the mandatory vaccination. And should the law be found to be disproportionate because of criminal sanctions, my lord, the respondent state is willing to revise that law and remove the criminal sanctions and only allow the administrative sanctions. That is the administrative fine of payment of $360.
Counsel.
Yes, my lord.
Must respond to our lordship.
My lord, we submit that if the 6 months imprisonment is disproportionate, they can order for its withdrawal from the law and maintain the administrative fine. My lords, if we may borrow from the European jurisdiction, the European Court on Human Rights, in the case of Africa and the Czech Republic, interpreted or applied the 3-part proportionality test to mandatory vaccination law. And the European Court held that instead of punitive measures, preventive measures should be taken. And these include administrative fines. In that case, my lords, Mr. Vavrika had refused to pay a fine that was subjected to him because of refusal of allowing his 14 and 16-year-old children to submit to mandatory vaccination. And my lords, the court found that that penalty, the imposition of an administrative fine, was proportionate. And it said that in case there is criminal sanctions, that is those that involve imprisonment, those can be found to be disproportionate.
But
my lords,
the administrative fine you're talking about is hinged on criminal law. It's a criminal sanction.
my lords,
Upon conviction, if you're not sentenced, you have to pay a fine.
much obliged, my lords. My lords, I beg that we are persuaded, that this honorable court is persuaded by the decision of the European Court on Human Rights in Vavrika versus the Czech Republic. My lords, in that case as well, Mr. Vavrika had refused to subject his children to mandatory vaccination. And upon refusal, he was supposed to pay a fine. My lords, the European Court on Human Rights found that that fine, the payment of that fee, was proportionate. And I beg that this honorable court is persuaded to find that in case to allow the mandatory vaccination law and find it proportionate, because the respondent state is willing to remove the imprisonment penalty. My lords, in the alternative, the applicant submitted and relied on the Brazilian case, which held that mandatory vaccination of all adult citizens of Brazil was constitutional. My lords, we also submit that just like the applicant did submit and rely on that case, this honorable court should also find that mandatory vaccination law of all adult citizens of Buranda is constitutional. My lords, we submit that it passes the three-part proportionality test guaranteed provided for under Article 43. My lords, we submit that this mandatory vaccination law is necessary because of the numbers that have been affected by COVID-19. We also submit, my lords.
Counsel, how do you reconcile your submission on mandatory vaccination and the guidance that is given by the Patients' Charter on consent to healthcare?
My lords, it is the submission of the respondent state that although patients or the government has a duty to seek or to obtain the consent of patients when it comes to medical care, we submit that vaccination is not subjected to those who are patients. Vaccination is done to people, potential patients, because of the spread of the pandemic. And so, my lords, the adult citizens, the people that will be subjected to this vaccination are not those that have already contracted the pandemic or the virus, but those that haven't, in a bid to protect them. My lords, we also submit that with mandatory vaccination, the stay-at-home orders, the quarantine, the refusal of admission to, or the closure of schools and the general economy shall be opened or shall be lifted. Because with mandatory vaccination, we shall have herd immunity of the population. And therefore, although the applicants would like to submit that this is a violation of Buranda's obligations, it is also the state's submission that this will open up or will limit the number of rights that have been limited or infringed because of the different measures for the protection of the spread of COVID-19.
What do you have to say to the applicant's submission that forced vaccination amounts to torture and the right to freedom from torture is non-derogable?
My lords, it is the submission of the respondent state that a jab does not qualify, does not amount to torture. My lords, Article 1 of the Convention Against Torture and Other Cruel, Inhuman and Degrading Treatment or Punishment defines torture. And it says, and I will read verbatim, that torture means any act by which severe pain or suffering, in this case a jab is not that severe, whether physical or mental, is intentionally inflicted on a person for such purposes. My lords, the applicant submits that this is psychological torture. However, it is the submission of the respondent state that the purpose for this vaccination does not fall under that which is defined by the International Covenant, the Convention Against Torture. Just a minute, my lords. My lords, the purpose for this mandatory vaccination is not obtaining from a third party, from the intended vaccinated person or a third person information or a confession, punishing him for an act he or a third party has committed or suspected of having committed, intimidating or coercing him or a third party, or for any reason based on discrimination of any kind, when such pain or suffering is inflicted by or at the instigation of or with the consent or acquiescence of a public official or other person acting in an official capacity. We therefore submit that the mandatory vaccination law does not amount to a violation of the respect to dignity and prevention of torture enshrined in Article 24 of the Constitution. My lords, it is the submission of the respondent state that the measures that have been put are intended to, in the shortest time possible, reach the desired level of vaccination. That if the desired level of vaccination is reached in the shortest time possible before these vaccines expire, we shall have achieved herd immunity. And when it comes to such a person, my lords, I submit on behalf of the respondent state that the Director of Public Prosecutions may not continue with that case. In conclusion, in issue 1, I would like the respondent state submits that mandatory vaccination does not violate Rwanda's obligations held in national, regional, and international human rights law. I beg to proceed to make submissions in response to the applicant submissions on issue 2. Issue 2 states whether the failure by Rwanda to procure vaccines for its citizens was a violation of its obligations enshrined in national legislation, regional and international human rights instruments. My lords, the Committee on Economic, Social and Cultural Rights has guided on violation to the right, on violations to the right to health. Under paragraph 47 of its general comment number 14 on the right to the highest attainable standard of health, the committee has guided and interpreted that for any act or omission to amount to a violation, the competent court must consider and differentiate inability from unwillingness. Paragraph 47 of General Comment number 14 on the right to health states that violations only happen where the respondent state is unwilling, but do not happen or should not be found to occur where the respondent state is unable. My lords, paragraph 2 of the facts show that the state of Buranda is a low-income country.
This is a very good argument you make, but I disagree because unwillingness is demonstrated in you allocating the same miserable 3% year in, year out, even when you're faced with a pandemic. Wouldn't willingness instead be increasing it even by 1 percentile?
My lords, it is a submission of the respondent state that there are very many problems in Buranda. And my lords, paragraph 5, in conclusion, much obliged, my lords. My lords, the state of Buranda is faced with very many problems, including a war threat, including terrorism, and these forces the state of Buranda to allocate small monies towards the health sector, that is 3%, and having the rest to go to the defense and security sector. My lords,
Mr. Attorney General, your government is prioritizing a war threat to a pandemic that's on ground and it's killing people. You're prioritizing a war threat?
my lords, the respondent state is taking all the necessary measures to the maximum of its available resources, including seeking international assistance, such that health care can be given to its citizens. Much obliged, my lords.
The Attorney General, you're before us, so we need facts,
My lords, in the case of Sehad and others versus Attorney General, petition number 16 of 2011, the petitioners in that case relied on the Abuja Declaration that mandates all states on the African continent, members of the African Union, to allocate 15% of their budgets to the health sector. However, the Constitutional Court found that that was not something that the court could pronounce itself on, and held that it could not make an order nor look into the policies of the state of Uganda in as far as enforcing the 15% budgetary allocation to the health ministry. My lords, in conclusion, I submit that this court finds that the government of Buranda was unable and not unwilling to procure vaccines for its citizens, and therefore should not be faulted or should not be found to have breached its obligations enshrined in national, regional, and international human rights laws. If I'm no further...
Thank you.
Much obliged, my lords.
General.
Please permit the Deputy Attorney General to respond to applicant submissions on issue 3 and 4 and make prayers for the respondent state.
May it please this court, once again, my name is Najuna Nicholas, appearing on behalf of the respondent in the capacity of the Deputy Attorney General. I will be responding to the applicant's claims made in issues 3 and 4, and thereon state the respondent's prayers. On issue 3, the applicant submitted that the restriction of refugees' entry into Buranda was a violation of the rights enshrined under the national legislation, regional and international instruments. And while addressing this issue, the applicant submitted on the basis that we have an obligation under international law, specifically under Article 1, C to F of the 1951 Refugee Convention and the Organization of African Unity governing the specific aspect of refugee problems in Africa. This is a position that the respondent concedes with. However, the respondent does not agree with the applicant on the facts that are submitted before this honorable court. The applicant submitted that we have refouled refugees in Buranda. This is not a fact in our case. However, what the respondent state has done is to put border control measures, which time and time again, the World Health Organization has recommended as part and way of containing the COVID-19 pandemic. The applicant did not bring this honorable court to...
I am sure the World Health Organization agrees that these border control measures should be in tandem with the non-refoulement policy and your principle and your obligation under Article 33 of the 1951 Convention.
My lords, in response to your question, in response to your concern, I refer to the World Health Organization's recommendations for international traffic in relation to COVID-19 outbreak. Now, the World Health Organization in its recommendation recommended that in particular cases where the state has a mandate to protect its people, it can put in place border measures. Now, these border measures, as well were noted in World Health Organization China report on COVID-19, are in the world's history the most aggressive and the most agile measures that this world has ever seen. Now, this is a fact that the applicant did not bring to the attention of this honorable court. Now, also, that means that the measures are different in as far as the countries apply them. The countries in the global north may apply different measures, but also the countries in the global south apply different measures. Now, I would like to invite this honorable court to paragraph 2 of the facts. In the facts, it is indicated that what is indicated under paragraph 2 of the facts is a state that is crumbling. 1 million people have already died, and 3 million people have been affected. Now, the respondent state has an obligation to make sure that it protects its citizens. The World Health Organization has also, in its report, made it clear that in the wake of the pandemic, so many countries have put in place border measures, including total closure of those borders. The case of Buranda is different. The case of Buranda is that the refugees that cannot test positive to COVID-19 are allowed into the country. That is a border control measure and not a border closure like the applicant would like to state it in this particular case. And it is the respondent's submission that this honorable court can not as well rely on the applicant's submissions in reliance to... Yes, my lords, the applicant submitted before this honorable court that these obligations under international law are binding on the state of Buranda. This is not true. The principle of pacta sunt servanda applied on by the applicant is has an exception provided for under Article 62 of the Vienna Convention on the Law of Treaties. Now, my lords, the respondent at this point would like to conclude that whereas the applicant has submitted before this
so what's that exception?
Yes, my lord. The exception under Article 62 of the Vienna Convention on the Law of Treaties is the fundamental change of circumstances. In short, states parties to conventions can do away with the principle of sticking to the convention in case circumstances change in their nations. And my lords, we submit that there was a fundamental change of circumstances.
Is your submission that if circumstances change, then state parties are absolved from their international obligations?
My lords,
Or they are absolved from the good faith principle?
they are absolved from the good faith principle, and this can also be an avenue for them to do away with their obligations under the Vienna Convention of the Law of Treaties and other treaties they are parties
Tie
to.
that back to this case. So what are you absolved from doing? You're
Much
absolved
obliged,
from
my
receiving
lord.
refugees and the non-refoulement principle?
No, my lord, because there was no actually refoulement in this particular case. So this argument did not hold water for the applicant to the respondent. Yes, my lord.
Non-refoulement is essentially any time you send back a refugee to a country where they face the threat of prosecution by virtue of their race, religious affiliation, political affiliation, and social grouping. So these people have run away from war. There is an immediate political and social danger to them. They come to your border and you send them back. Haven't you committed the same thing that Article 33 seeks to protect?
My lord, what the respondent submits before this honorable court is that actually what happened is the state of Buranda putting in place control measures, but not stopping them or returning the refugees to their countries.
Were your control measures proportionate and in good faith?
Yes, my lord, and because according to
a quarantine center have been more proportionate and in better faith?
We submit that in the circumstances of the case, quarantine wouldn't have been a proper case, because why? The refugees that are coming, first of all, are not tested. These people cannot be put in the same place, and neither can they be separated because the state does not have such resources to help them individually. So
nice
they cannot
that you
be
mentioned
quarantined.
that Article 35 of the 1951 Convention gives you an avenue to request the UNHCR for resources, and they are oftentimes willing because they recognize the burden of host states. So did you undertake any efforts under Article 35?
My lords, we submit that there was actually no imminent need that was identified by the respondent, because the condition that was put in place was not that these refugees be turned. However, it is a control measure put in place not only for refugees but for everyone who is entering the country. And this is my lords, we submit and rely on paragraph 9, which I will read verbatim of the facts, that Buranda requires all persons entering the country through its borders should be vaccinated. This is under paragraph 9, line 1 to 3. Yes, my lord. Yes, we recognize that refugees have special rights, which we could not provide in this particular case because they were considered generally. No, our actions are justified and were done in good faith in the interest of the state, which was facing a very difficult situation in the pandemic. In good faith, yes, the respondent would be in position to take this honorable court's wisdom.
Is it possible for that state to do an act which is in violation of the right,
The respondent state has an obligation to indeed provide acts as advised by the court, and it is possible. My lords, if the respondent is of no further indulgence to you on issue 3, I will now proceed to respond to the applicant's claims made in issue 4. On issue 4, the applicant submitted before this honorable court that the continued implementation of the standard gauge railway project is a violation of the national legislation regional and international instruments. This is a position that the respondent once again vehemently contests. And in their submission, in the applicant's submission, the applicant submitted and relied on the case of on Uganda National Roads Authority versus Irumba Asman, in which indeed the Supreme Court reiterated the right to the right of the state to take land, however, under some specific circumstances. We submit before this honorable court that the facts of this case, contrary to what the applicant submitted, show a state that has actually not deprived the land, but a state that has only threatened to deprive the land. But in addition to the threat, it is willing to compensate the people, the Bachwezi people in Buranda. On top of compensation, it is willing to go ahead and relocate them to a land that is 10 times bigger than the land that they apparently occupy. Yes, my lord, we recognize that actually construction has already started, and the respondent also takes cognizance of the devastating effects of the construction on the 20 families of Buranda. However, this is a situation that that the respondent has recognized. However, still in the process of making sure that every one of the Bachwezi people are satisfied after being compensated. And we take cognizance of the rights of the Bachwezi provided for under Article 26 to own land. And in breach of that right, the respondent state is willing to compensate their land and also relocate them in the public interest. My lords, much obliged. The respondent submits that there is contradicting facts in this particular case. My lords, would like to submit before this honorable court that the respondent state takes cognizance of the Supreme Court's position in Uganda National Roads Authority versus Irumba Asman, in which court, yes, my lord, in which that court noted that the state cannot go ahead to start or to deprive land without compensating. And this is a position that we intend to respect. Compensate before depriving that land of the Bachwezi. No, the respondent is actually stating to this honorable court that there are contradicting facts in this case.
No, actually, in general, you can't concede. You know? There are certain issues that you cannot push. You concede where necessary.
Yeah, one fact is that the government has not yet deprived the land. Yes, it is threatening to deprive the land, including compensating them. And then the other fact is that actually some people have been displaced. This is a very unfortunate fact that we have in this case that have not been harmonized together with the bill. Yes, my lord. In any case, the respondent submits that where the construction has started is not where the Bachwezi live, but the floodings that have actually gone way to where the Bachwezi live. So where the construction has begun, the Bachwezi are not occupying that place, but the floods that have... Yes, my lord. Where did you get that from? The facts show that the effects on the 20 families is as a result of flooding. No, that's not what I'm asking. My lords, I would like to refer you to paragraph 13, line 8 of the facts. And it notes that Chair Bachwezi has also noted that to date that construction work has caused flooding around the land they occupy as a community, leading to the forceful displacement of over 20 families. Now, whereas... This very fact shows that my lords, the respondent kindly submits before this honorable court that we cannot be guided by the facts because they do not bring out the... They state that prior to the commencement of the construction, whichever Chwezi requested the government to redesign the plans of the SGR project, such that the SGR project does not pass through their ancestral and community land. Now, my lords, these facts indicate that the railing, which only passes through their land, so it means where it is possible, because we are not sure of these facts, it is possible that the construction has already started on the land that is not for Bachwezi, because it passes through and it is not only going to be in the land of the Bachwezi. The respondent kindly submits. And my lords, thank you. If this honorable, with the leave of this honorable court, the respondent will make his prayers. My lords, in response to your question, the respondent will rely on Article 1 of the International Covenant on Civil and Political Rights, which provides for the right to self-determination of indigenous persons. Yes, my lord. No, my lord. In this particular case, also, Article 1 of the International Covenant on Civil and Political Rights do provide for the right to self-determination of indigenous persons. Also, this right is provided for under Article 12 of the African Charter on Human and People's Rights, and the African Commission has also pronounced itself on the same in its work titled Indigenous Peoples in Africa. And the African Commission notes that indeed, by the use of the word peoples, the collective rights of indigenous Bachwezi, the indigenous people are recognized. And yes, in Buranda, we do also recognize collective rights, because as seen under Article 237, land can also be owned customarily. So, but also under Article 26, land can be owned either individually or in association with others. And it is the applicant's, the respondent's submission that yes, the rights of indigenous persons are recognized under the Constitution. When negotiations do not become fruitful, in that particular case, in the public interest, the state will go ahead and deprive that land forcibly. Respectively, this is a condition that has been put on by the Constitution. When these negotiations cannot proceed or cannot be fruitful, then in the public interest, much obliged, my lords, and the respondent would like to pray that this honorable court dismisses this claim. Thank you.
Most obliged, my lords. Thank you for your guidance, my lord. Article 26 is couched in that manner that no person shall be compulsorily deprived of property or any interest shall. To this effect, the actions of the government are a violation of the right to property of the Bachwezi. In relation to issue 3 about the foreign policy, I invite this court to look at objective number 28, which provides for the foreign policy, and particularly look at 1B, which is to the effect that the foreign policy of Uganda shall be based on the principles of B, respect for international law and treaty obligations. And then 2, talks about Uganda shall actively participate in international and regional organizations that stand for peace and for the well-being and progress of humanity. Humanity is the most important part here because the refugees are part of the human race. And the doctrine of Ubuntu entitles the government of Buranda to admit the refugees. Most obliged, my lord. The other issue is on the case that was cited, the Sahad case. In that case, actually, it was said that in as much as the resources are limited, it should not be used as a means to defeat justice. And to that effect, court declared that government should provide the medical necessaries. In regard to cruelty, what might amount to cruelty? In the case of Speciosa Wandera Kazibwe, it was stated in that case that any cruel act. My lord, I invite you to look at the specific act of cruelty, how court came. The parties are Speciosa Wandera Kazibwe versus Kazibwe. My lord, in that case, it was said that cruelty does not amount to physical harm only, but can also be emotional. Most obliged, my lords. And to end it up, my lords, I invite this court to take cognizance of the fact that the objectives are justiciable pursuant to Article 8A and the case of Amot Nyakana versus Nema, where Justice Bat Katurebe said that the objectives are not only there to aid the government to pursue its objectives, but can as well be justiciable. I beg to submit.
Yes, good evening. I know you are so tired, but I'm more tired than you. Okay? But let's give ourselves a hand of applause. All of us. Okay, let's just clap for yourself, okay? Now, I want to start by thanking all the teams again that have participated in this year's competition. I thank all the oralists. I know this is the time that we all tend to shake. But worry not, the Lord is in control, okay? I am certain that this competition shall put you to another level, okay? I'm going to ask that the persons that have those awards bring them in front because we are not going to waste time. Once we know who is the winner and the runner-up, we shall start with the awarding so that people can leave before 7, okay? Again, I apologize for the fact that we had a 1 hour lag, okay? And if you notice, you'll agree with me that because of that 1 hour lag, we could have been out of this place by 5. Okay? And I apologize. My aim was to ensure that by 5 we are done, but the rain caused some problems that I couldn't control. Again, I do recognize our beloved Dean. Again, guys, clap. Okay? Okay? And Dr. Therese, again from the Faculty of Law, who was also clap. I also appreciate the court clerks that have made it a success today. Okay? Of course, I know my judges are still tallying, but I cannot thank them enough. I know there's a time of closing, so I'll stop here. And only mention that if you know you've not filled in the feedback form, kindly fill in that feedback form, because next year when IU is hosting, as we've been informed, we want to ensure that we take this competition to another level. We want this competition to be the JESAP of Uganda. Okay? And that can only happen when I get your feedback and I act upon it. Just like you saw this year, we acted upon the feedback, including timekeeping. So if it wasn't for that, we could have been great. I cannot thank enough the guys from MCI. Please clap for them again. They have made us shine wherever we are going. I'm very certain when you type and check the Twitter, you'll find your picture if you've been submitting. And for those who've been watching, I'm certain your picture is also somewhere. So you'll be famous on Twitter just because of them. Again, my friends from Baba TV, we always have a saying, Obusoga Buraire. So, nze ndi kukoba nti tugenda kukola bulungi. Tusiimye ino, ino, mwebale ino, Baba TV. Mubakubire mu ngalo. I also want to thank NetPil that has made it a success. As you can see, this trophy is gold, okay? As you can see, gold, eh? Original, by the way. We had to investigate, okay? So all this was possible because of the funding we got from NetPil and the support we got from NetPil, okay? However, I also want to add and appreciate each and every coach. I mean, if you know you've been a coach, just stand for recognition. If you've been a coach for any university, just stand for recognition. Myself, I've been a coach. Okay? But I know I've also been an organizer. But the point I was drawing at is that I've been a coach, and coaches tend not to be recognized. They tend to focus on only the oralists. And they forget that we are the guys that make the oralists. So again, let's clap for them again. Finally, I want to appreciate the team from the youth. I tend to like using UC, but the other day he told me to use CU, not UC. Mr. Ocho from the journalism school, we appreciate you as well with your team. Again, I also want to thank each and everyone that made today a success, including, this was intention to stop this by the end here, including, all of you have seen on YouTube, right? You've been streaming, right? Have you noticed? In case you don't know, when you finish this session, type in Tanya Innovations Africa, you shall see yourself shining, okay? So we appreciate Tanya. Again, Evans, just stand for recognition. So I appreciate yourself and the team from Tanya Innovations and to the students of this university. Nowadays we use the word mighty. I will not talk about the rest. But we thank you for having made sure that our participants, our guests, have a very good stay. I have not received any complaint. I know universities where you go and you want to run after your round because you're being intimidated, but I have heard that the reception has been great and this can be attested to. So I am very certain that we can make this a success. Now, I can speak for the whole night, but I'm very tired. Now, because of that, I just want to confirm with my judges whether we can go ahead and announce the teams that are taking this home. Thank you. Just remember, every oralist is a winner. Some are going to get certificates. Others are going to be announced as the best oralist, male or female. Others are going to take certificates of participation as an institution. What else do you want, surely? Thank you very much. Yeah, so I've noticed we are still live, and I'm just thinking that perhaps as we wait for the awarding and everything, perhaps we could have the dean making the closing remarks, so that after that we do the awarding ceremony and we all go to our villages. Thank you very much, Prof. You're welcome.
Thank you for being a good anchor. Honorable judges, all protocol duly observed, our oralists, the finalists, and the others, our students from far and near. I said our students because we are all our students, whether from Cavendish or from any other university. We want to really appreciate you. If you make a meal, a decent meal, and you have invited people, and they refuse to turn up, what happens? It's going to become a waste. But we have set our table with our different dishes, and you have come to dine with us. And indeed, we appreciate you coming. For the students that have come from far, we pray that the Lord will take you safely to your destinations. In the mighty name of Jesus. To our judges, we cannot thank you enough. Because Nemo Jus Dex in Cosa Sua. You cannot be a judge in your own cause. It's one of the fundamental principles of natural justice. So we needed the umpire, and we have the umpire. If they didn't consent to come, we didn't give them any money, but they consented to come. This is a form of CSR, contributing to the society and making the world a better place. A round of applause for our judges. Several issues have come up. Incidentally, I teach forced migration and refugee law at the master's level. And seeing the oralist and the arguments, I was quite impressed. And I see the level of research with the judges and with the students. And this is a very sensitive matter in international law. I want to come into your territory. You are saying I cannot come in. The international law is saying that if I have a fear, whether reasonable or not, you don't have to test the reasonability, but first of all, allow me in. You know, it's a funny doctrine, isn't it? And they have argued back and forth. And I know that all the things that we are doing here, we are sowing a seed for the future. So I don't want you to relent, because this is how we change the law. You know, the court gave an hint. It took the hint, said we will go back, because there are things that need to be improved in our laws. We talk about human rights. We talk about different kinds of rights. And you see, once you strip any human being of their rights, then they are no longer human. The day you woke up and you woke up to become a human, then you have your human rights. In some jurisdictions, they have respect for animals, such that you cannot just hunt animals anyhow. I had a first-hand experience about animals when a skunk, you know, wanted to build a house near my apartment when I was in Toronto. And I was like, this thing that looks like crabbies, we can kill it. And my landlord told me, he said, no, you dare not. That's a crime. And we had to wait for another 3 days before the animal rights came. And they were petting the animal, dancing around. What could have been a game? You know what I mean by a game? Bushmeat, solid one, in this part of the world. But they were petting the animal and dancing around it just to take the animal. So if animals could be accorded such rights, how much more human beings? We should not treat ourselves lesser. And that is why it pains me when I hear stories of xenophobia. It pains me when I see racism. It pains me because how can human beings discriminate against human beings? We have the same blood flowing in our veins. I want you to go out there and make the world a better place. There are just two people in the world, the good and the bad. Immediately you start thinking about your tribe, your ethnic, your country, then we have the problem. You are either the good or the bad. In your own little corner, what are you doing to improve the cause of humanity? What are you doing to improve the lot of the people around you? Are we just blowing grammar? What are you doing? It is good to always say, the government show, and when you get to the same chair, you repeat the errors of the past. I've said it, go out there as advocates, create awareness, and let's make the world a better place. I want to appreciate every one of you. I want to appreciate the Tanya Innovations, Network of Public Interest Lawyers, all other participating institutions. I can see Makerere, I see NU, IUIU, Bishop Stuart, the Ugandan Pentecostal University, and UCU, and every other institution, and Cavendish University. I want to appreciate all of you for coming together to organize such a beautiful thing as this. I'm actually proud to be part of this. It's a good thing. Thank you once again. God bless you. And to the winners, somebody must win, but we are all winners. Godfrey has said it. We are all winners for participating. We are all winners. So whether you have a certificate of participation, or you are the best oralist, or you are carrying the trophy, the truth is that for setting out your feet, going out there to represent your constituency, you are a winner. So I congratulate all of us as winners. Thank you very much, and have a good evening.
Thank you very much, Prof. I wish we had 2 more hours. I have enjoyed myself. It's as if we are actually going to another Moot session. But thank you very much, Prof. And indeed, next time we should have another Moot where such kind of something looking at xenophobia could be very interesting. So my students, take note, okay? So I want to invite Mr. Evans. He has an announcement which is very key that all the participants may want to listen to. Thank you.
Thank you, Godfrey, and the judges for today, plus the participants. I will say it has been an excellent day, and I can say I'm so excited. But I'm here to make an announcement in relation to Tanya Innovations. Tanya Innovations is a platform that started during COVID, and the prime message is to connect Africa. My dream would be to this courthouse that sometime it will be so powerful to see maybe a moot court in Nigeria, North Africa, all of you converging and having this type of competition. Because I think this brings us together, but we have to make Africa a reality. And that's what Tanya Innovation is doing. So we shall always be, I don't want to say that we shall force ourselves on you, but because that's the passion and the challenges we got during COVID, we have no room for, okay, I will not use that other word, but we have to move. So we are always there, and we shall always stand with you. Tomorrow, we have Professor David Justin Bachivinga. I know, I will suspect that possibly our judges here, one way or the other, you have gone through his hands. He's such an icon in Africa, and we shall be hosting him on Tanya Innovations Africa at 8 p.m. till 9 p.m. So since he's from the legal fraternity, he's a celebrated scholar on our continent, I will invite you to tune in at 8 p.m. to 9 p.m. Just like we have learned from here, I'm sure there are so many things that we'll learn from his experiences, and he has his he has his book that he's yet to launch, and I'm sure that we could pick 1 or 2 things. So my announcement is in that direction. Otherwise, I wish you well, and I hope we have picked our lessons and we can make Africa, Uganda, and our continent better. Thank you.
Yes, I meant the squash sheet, okay? Okay. Finally, I will not waste time. The best oralist for today's session is Blessed Atwine Mugisha. I mean, stand for recognition. Okay. Now, in terms of the results of the team that won and the runner-up, Team H had 75.1 as the overall average from all the judges, and Team B had 84.3. Shall I finish? Okay, let me finish, yeah? Okay? Okay? I see the dean is very excited. I'm hoping there will be a dinner where the winning team shall be appreciated, but that's a discussion for another day. So it's my utmost honor to announce that Team B is the winner of the third. Okay, let me finish and then you can clap, okay? Team B is the winner of the 2022 third annual National Public Interest Litigation Moot Court Competition. So I want to invite, again, let's just give one more round of applause to our judges. I would have loved them to just introduce themselves and where they work, if they want to do that. But I want us to start with the award ceremony, and if time does allow, if you guys appreciate that, I would love to see that done. So I don't know what you're the judge. Awards. Everyone is tired. Okay. So do we start with the runner-up? Okay. So this is interesting. I want to invite the dean, Dr. Therese as well, and the presiding judge to kindly award the runner-up. Okay, I've been guided by the judges, and I have to always follow the advice of the judges, just like you. That the dean and Dr. Therese and John Mary. Where's John Mary? Shall we get John Mary here, please? Someone get John Mary. Okay? John Mary should also be here. So yes, John Mary. I'm waiting for John Mary, and then we can do the awarding. John Mary, I think I can see his shirt. Yes, please come. So John Mary represents NetPil, and I don't want to be fired, okay? So John Mary will also join the team that shall be awarding the runner-up and the winners. But then after that, you kindly move towards the judges' bench, and then you shake their hands to appreciate, okay? So Dean, please, let's clap for the Dean and Dr. Therese. The runner-up, please, let's make this fast, okay? So this goes to the first oralist, okay? Yeah, the whole award, yes. At least let's clap, okay? And then the second oralist. Again, I have to give this to the dean just for a second. Can we see the coach for this team at least also come along? Please, let's clap for them. Coach, please come along, okay? We have to appreciate your work. Another round of applause. Okay, I think they want a photo shoot before we do the winning team, okay? A photo shoot for the team that was runner-up. John Mary, I know you like hiding. Come in front, okay? Oh, John Mary, that you come closer. This other side, okay? Shall we press this other side? They look smart, right? Especially the judges. Give me some smile, eh? Thank you very much. Thank you very much. Now, finally, I want to add this comment before we have the final team, that there was an award awarded earlier that Team B, which was Cavendish University, had the best memorial. So I also want to issue that award now. Let's clap for them. I am just trying to locate it, okay? Just a second as I locate it. Yeah, there it is here, here. Okay, again, guys, come along, okay? So I can't do two things. I know I was a coach, but I don't know how to do this. Do I have to join the photo with the mic? So as we congratulate you, now I want to announce the winning team as Team B. And I want to ask that this trophy is held together with the leading judge. What's the word? The presiding judge, okay? The PJ, so that it will go in the record that the PJ to be held our trophy, okay? So that this photo is taken. Yeah. Let's clap for her again. Let's clap for her. It's not easy. Okay? So, Dean, again, you hold the trophy together with the students. And then our PJ. Looks like I also need to be in that one, eh? Thank you very much. And guys, if you drop, it's up to you. So now the medals, then we go home. Yes, you come back for the medals, Prof. One more round, okay? So the best male oralist, I've been informed, was Blessed Atwine. Overall, yes. Okay? So again, Prof. At least you clap for this one, eh? Yes. I just want to consult on that. We have a medal for the best female oralist, but as you saw on the final, we never had a lady. So we are trying to consult the best way so that we don't delay you. Okay, so we've agreed that the award for the best female oralist shall be couriered to the winning team because of time, and their score sheets are in another room, which we don't want to go to now. And it needs too much calculation. So that shall be done, and NetPeel shall do the couriering of this award to the respective team. Now, very fast, we have awards for our judges. So we start with the judges. Migade Patrick. Let's clap for them. Asio Patience. Abio, Patience. Teddy, think I'm tired. Guys, let's clap for the judges at least. Honorable Esther. Let's clap. You stop clapping when you become a judge, okay? Honorable Bagara Esther. Then Justice Chisache, our presiding judge. Then Justice Okot. Okay? Let's clap, guys, okay? Justice Chisache. Justice Juliana. Let's clap for her at least, okay? Again, let's clap for her. And then Justice Okot Robert. Thank you very much. Now we have certificates for the participating institutions, Gulu University in that order, very first. Islamic University, Kampala campus, very first. Gulu University. I saw the dean, doctor was around, I saw him around. And then we have Islamic University in Uganda. Doctor, please, you want to come in front. Doctor, there is the dean, faculty of law, Gulu University. Flew from Gulu. So let's clap for him at least. Okay? Doctor, please join the photo. Go on. Someone is saying Igwe. I don't know what it means, eh? Sabwenje. Islamic University. Are you? Let's clap for them. Uganda Pentecostal in that order. Then Bishop Stewart in that order. Very fast. People are tired, okay? Sorry. Bishop Stewart. Sorry. Again, Bishop Stewart, I'm waiting. A round of applause. They came from very far, the land of milk, okay? Let's clap for them. Bishop Stewart. Bishop Stewart. Let's clap for them. We have IU Females Campus. It's not female, but Females Campus. Nkumba University. Let's clap for Nkumba. And then we have Nkumba. I'm waiting for Nkumba. Please, let's be fast, okay? Nkumba University. Let's clap for them. Can we go ahead? Go ahead. Makerere University. The Makerere University. Where are they? Any representative for Makerere University? Okay. Oh, Mr. Pilak, Mr. Netpil, Mr. John Mary. Let's clap for him. And then we have the Uganda Christian University. I repeat, the Uganda Christian University. Mr. Bwamba, let's clap for him. A man of few words, but too much action. And then we have Kampala, the Kampala International University. Or do we say Kenyans in Uganda? Kampala International University. Let's clap for her again. So, okay. Cavendish University, Uganda. Cavendish University, Uganda. Guys, please go on. Okay? Okay, can we have the president of the Law Society come, join them? Okay? Please clap for her. And the incoming president as well. Now, the runner-up, do not worry. You've been sorted, okay? I'm surprised, okay? Yes, this is heavier than the other trophy, okay? Now, the runner-up has managed to attain a very interesting award, the Dean Shall Award. Let's clap for them. Again, the runner-up, let's clap for them. Now, we have individual certificates, but because of time, we shall only issue those certificates to the team coach, who shall then deliver them to the respective oralists, because I mean, you're all tired, okay? So what I would advise is, before you go, you kindly see me in my office, the team coaches, so you can pick those certificates for your respective teams, okay? Yes, it's theirs. Again, do you also have something to cover it? Don't put in a box, okay? Just, please, okay? Just a case. So you can put money there. Thank you very much. Okay.
All right. Thank you very much. Iran Godfrey has given me the opportunity to give the closing remarks. On behalf of the organizers, both here at Cavendish and at NetPeel, would like to thank you all. Would like to thank Cavendish especially for agreeing to work with us for this year's Moot. Dean, we are very, very grateful for this opportunity, and help us send our regards and gratitude to the school administration. All the participating teams, all the universities that have participated in this year's Moot, we are also very grateful. Our end game is to ensure that it's a learning experience for you, and we hope that you've been able to benefit in very many ways from participating in this year's Moot. For everybody else, our partners that we've worked with, both television and catering services and the live stream, I don't know the names of head, but we are also very grateful for the services that you've rendered to us for this year's Moot. Thank you very much. To our judges, the selflessness that you've put in to be with us this entire day. Thank you very much for your time and for guiding our students in this exercise. You're very much appreciated. And to the students, thank you very much for taking time off your busy school schedule. We know that most of the times the Moot is not graded as part of your academics, but for taking off time and agreeing to participate in the Moot, we hope that you've immensely benefited from it. And from us, we wish you the best of luck. To everyone, as you go home, safe journeys, and good night. Thank you. Departure is at leisure. Otherwise, we are done. Thank you.